Ladyship Justice Rotho and Justice Talapatra, and as per the Register Judicial, it has to now come before the bench, in which Justice Rotho is a member.
It will come.
My lord, writ appeal number 49 of 2024, my lord, the state has filed. After state has filed the writ appeal with limitation, I have filed my objection. Due to the filing of the writ appeal, my lord, now they have stopped my provisional pension. So I pray matter may be listed for hours, my lord.
Give your slips, all slips.
Item number 29 from the board minutes. Your Lordship, yesterday it was before Your Lordship was item 66. I prayed for it to be taken up. Your Lordship has asked me to mention it.
It can be taken up.
Item 29.
Can be taken up.
Item number 1.
Lord, item 1. The CMAPL filed for restoration of the writ appeal, my lord, which was dismissed for default on 14/11/2019. Lord, in fact, this CMAPL, my lord, this itself was dismissed, and for which another CMAPL was filed, which your lordship recently has allowed, my lord. I'm just submitting the copies, my lord, for lordship's reference, wherein your lordship has allowed this CMAPL subject to deposit of 20,000 rupees to all the other opposite parties that we have already paid, my lords. So this present CMAPL has been restored today, which has come up before lordship. I just
So
pray,
that was restoration for restoration.
my lord, that is a
My-
only I pray, my lords, if this may be allowed, writ appeal may be heard on merits. 20,000, my lord, we have already deposited.
Yes.
So I do not have a copy of the restoration application, but in fact there is a 42 days delay in this.
Notice had come.
Notice.
They have appeared for OP5 and
Others?
OP contesting parties OP5 respondent 5. Others, my lord, the state is there for respondent 1 and 2.
And what is the point in your appeal?
Motion may fix a date, my lord. My lord, the order of the consultation commissioner was challenged by the respondent number 5, which has been allowed by the learned single judge, my lord. That is under challenge, my lord, in the writ appeal relating to property, my lord. Scheduled property. Lordship may fix a date for hearing, I will, my lord.
The learned lawyer allowed the appeal to be dismissed. Then
My lord.
the restoration application also to be dismissed for default. And then my lord should hear the appeal expeditiously.
My lord, the previous counsel was
Issue notice.
You accept
So
notice?
accepts notice on behalf of IA number 6 of 2022. This application has been filed for condonation of delay of 42 days.
42 days.
But he is appearing, no? OP1 is?
For state, I am appearing.
You are there for?
OP5.
Okay.
You are appearing for 1 to 4.
Yes, sir.
Just see the first item.
No.
Who is
Yes, I will
OP?
appear for 1 and 2 minutes.
Who is 3? 3 to 5 were appearing.
No, only 5. I am appearing for
Then
only 5.
3 and 4, my lord, notice may go. Notice already was issued, but no one has appeared.
Sir.
Already
But
in that
three is
another
father
CMPL
of-
they are already appearing, but this one
Three is
same
father-
parties, my
Sorry,
lord.
4
If
is
a lordship-
father of 3.
if a lordship permits,
My
I will serve a copy to them, my lord.
In fact, 4 is DC. 4 is no more in this.
No more, my lord.
Because in the other
Legal
case,
substitution
other
was
case
filed,
you have,
my lord.
so you have to do that.
I will, my lord, notice may go to 4, my lord, exponent 4.
4 is
What
dead.
about
This
3?
one 4 is dead.
4 is dead.
Date, my lord, we had filed the substitution. I will file in this petition also. I will file, my lord.
Exactly, other case you are aware, but here you have not filed
Here I will
substitution.
file,
Other
here
case
I will file.
substitution was allowed thereafter.
It was, my lord.
Current counsel appearing on behalf of the petitioner seeks adjournment to take steps for substitution consequent upon death of opposite party number, respond number,
4,
4 months.
opposite.
opposite party number 4. As requested, is this matter on 4 weeks.
Item number 2.
P5 you are appearing. So P5 you are
Month,
appearing.
month.
My,
So I also have entered a prayer.
Copy may be served.
I will serve, I will serve.
Item 2.
Lord, I have filed the counter. Noting is that counter is not filed, but counter has already come. I have already filed the counter on 11th. Or DM.
Scanned also.
My lord, yesterday there is a demise in my family and today I am not prepared in this case. Kindly adjourn the matter.
Oh, this is
next-
PIL. Is this PIL?
No, my lord.
Huh?
No, my lord.
As requested on behalf of the petitioner. This matter on when?
Next week any day, my lord.
Next week. Copy of counter affidavit filed on behalf of opposite party number 1.
We have filed.
2 and 12 I have filed for DMT.
Opposite party number 1, 2 and 12.
Yes.
Then copies of the counter affidavits have been served upon
Yes.
counsel for the petitioner. When counsel for the petitioner shall be at liberty to file reply to the said counter affidavits. Replies. Yes.
Item number 3.
Since this item may not, my friend is right. My friend is right.
So Senapati, let him, will it help?
My
you?
friend is right that amount has not been credited to the account, where the government had placed the funds with the principal BJP college. He requested the treasury officer to pay the amount, but treasury had objected, saying that one portal has to be raised. She did not carry it out. So in the evening, I have asked her, you pay through check. The person has already reached my office with the check in the name of the petitioner. Within 10 minutes, I can hand it over. Lossi may only give some time. I will get the check.
At 2 p.m. At 1 p.m.
Before that also, I can get
At
it.
1 p.m.
Yes.
Case admission item number 4.
Item 4. So Lordship condone the delay subject to payment of 46,000. That amount has already been paid to the petitioner. I'll serve a copy of the appeal memo. Let the matter come next week.
Let's serve a copy, my lord.
As requested on behalf of the applicant, list this matter on next week.
Item number 5.
Copy of.
May I please, your lordships? Your lordship, the petitioner, the appellant here was appointed against an order which is at page 17 of the brief. He was appointed in the position of a programmer cum training officer. It's at page 17. Thereafter, he was promoted to the position of a system analyst, which is at page 21. Thereafter, the position of a system analyst was redesignated to the position of an assistant director of MIS, and this is borne out from page 23 of the brief. At point 6, it was decided to redesignate the position of system analyst as assistant director MIS.
What is MIS?
MIS, your lordship, is
Sorry, madam. What is DOPT?
sorry, your lordship.
DOPT. How can you argue? Come prepared.
Your lordship, I may pray for a short passover. My learned senior, Mr. Mukherjee, will be arguing. He's on his legs in another court.
All right. You could have said in the beginning. As requested on behalf of the applicant, this matter next week.
Item number 6.
Please, your lordship. Shall I prefer Passover, my lord?
All right, 1 week. Yeah, mention slip. Huh? Hey, mention slip. Mention slip.
mention slips you had kept. Specific to the order.
No. Those matters which are listed on the road basis, mention slippage is simple. Basic adjustment to. Right.
No, it was to be distributed.
What?
From distributed.
Huh?
That is good maintainable and after the difference.
Yes. Item.
Item 6.
No,
My
sorry.
lord, after recess, my learned senior will assist you regarding
No,
the
no,
maintenance
no.
After this, there is no bench.
No,
A short passover, I will.
this is not.
Item number 7.
My lord, yesterday the petitioner oblique appellant have filed a written note about 10 pages, my lord. I am to go through that, my lord, I need some time. Affidavit, reply to the affidavit, yes, I have to go through that. 10 pages.
Lordship, so far as that reply is concerned, that is only for the intervener is concerned, Your Lordship. The matter we are challenging, Your Lordship, so far as the virus of the rule, Lordship.
My lord, may recollect that the exemption of TET
Yes,
qualification. My lord, they had, my lord, after our submission, they have, by filing a bunch of documents, raised 4 contentions. That was required also to be giving a reply, my lord, after affidavit, reply in affidavit. They served copy on 12th. I filed my reply affidavit on 13th, and I have served copy. My lord, may I pray, my lord, I am not objecting, my lord, to what my lord senior is saying. Only I pray, my lord, in support of that affidavit, reply affidavit, I have prepared a spiral bound volume, my lord.
You don't want us to decide.
My lord,
You don't want us to decide the matter.
my lord, I could not follow, my lord. Sorry, my lord.
Don't you want us to hear and decide the matter?
It's not any other day, my lord. Lordship, my lord.
But if you are ready, why any other day?
My lord.
He is asking for adjournment. Why are you?
Yes, my lord. That's why I let it be come, my lord, so that it will be.
That
Let them go through my reply affidavit. Let it come, my lord, any other day.
In WPC number 21547 2023, I am filing the written notes of submission, Your Lordship. Only, Your Lordship, I am filing today the written short written notes. And I have challenged the virus of this. Yes. My lord.
File in the registry.
Please supply a copy to us.
Little.
A copy of the written note filed by Mr. Ratha
Yes,
kindly be
I'm
supplied to us.
Yes, I'm now serving.
We are for the interveners.
There are two Mr. Rathas here.
Yes,
Which Ratha you want?
As jointly requested on behalf of the parties, this matter on 4 weeks.
Your Lordship, short date may be given, Your Lordship. Lordship, short date, your Lordship has already, Your Lordship can have a glance to the order dated, Your Lordship, 21/8/2024, Your Lordship. Where Your Lordship has specifically directed that this matter regarding for challenging of the virus of the elementary teachers cadre rule, Lordship. No further adjournments will be given.
Today we are not granting any adjournment. Can't do. Make your submissions.
Yes, Lordship.
But,
Sorry,
So what is your problem? You have given, so you have to also.
but I have to file an, that is the
no, sorry,
File- file-
supported
sorry.
document.
File now.
Malad, I have made it.
Yes.
This is not the way. Make your submission.
Malad. Malad, before I make my submission, Lord, may I just be permitted to refresh the memory. Here the case is, Lord, in 1987 cadre rule was governing the field for class 1 to 7. RCFC Act came into force in the year 2009. But after RCFC Act came into force in 2010, RCFC rule was framed by the central government, and also RCFC rule was framed by the state government. Malad, accordingly, in terms of Malad, section 23, Malad, 23(1), Malad.
Framed by who?
Malad,
Rules, you're talking of the section or act?
section 23 of the RCFC Act, Malad,
Okay.
from the BEAR Act. But qualification for appointment and terms of conditions of service. But any appointment, any person possessing such minimum qualification as laid down by the academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Or 2, where the state does not have the adequate institutions offering courses or training in teacher education, or teachers possessing minimum qualification as laid down under subsection 1 are not available in sufficient number, the central government may, if it deems necessary by notification, relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years, as the case may be specified in that notification. But the proviso is, first proviso is important. Provided that a teacher who, at the commencement of this act does not possess minimum qualification as laid down under the subsection 1 shall acquire such minimum qualification within a period of 5 years. But with this proviso, and in terms of section 23(1), NCT was notified as prescribed authority, and NCT by notification dated 23rd August 2010 prescribed the qualification. That in my, although that is available in my REIT application and all the REIT applications also, and I have also enclosed in this spiral binding all of the documents they are relying, also we are relying, for convenience sake, so that this can be utilized. My lord, your lordship will find at page 49, my lord.
Please.
Lord, if your lordship.
Are you commanding me?
No, my lord.
Please make your submissions.
My lord. 49, my lord. because my senior was taking the time.
No, no, we are hearing you, you continue.
But at least what I learned from the bar.
There was objection from your side that no judgment was required to be granted.
No,
Make your submissions, please.
Because the young lawyer,
All right.
my lord, at
Please
least
make your
I
submissions.
obeyed my lord from the
Please
beginning.
make your submissions. Please continue.
Mr. Sahu, you argued it earlier, so what is your problem? You are continue.
Yes, my lord, my lord,
Yes,
my lord,
continue.
my lord. Your lordship, page 49, my lord, of the spiral binding, my lord. Page 49. But the minimum qualification, as was notified by NCT, was made two categories. One for class 1 to 5 in terms of the schedule appended to the RCFC Act, and another is class 6 to 8. But class 1 to 5 prescribed secondary schools academic qualification and DLED or etc. That is the training qualification, and the teacher eligibility test pass is the qualification. That is also for the class 8 to 10, 6 to 8. The qualification is BA, BSc or the training qualification B.Ed. Thereafter also added and teacher eligibility test. This is the qualification. This qualification was also little bit modified by virtue of the subsequent notification by the NCT. That is 29th July 2011. That not to the extent of the minimum qualification which was prescribed along with the TET pass. Then what happened? While this provision was governing the field, my lord will find from the RCFC rule in consonance with the spirit of the proviso to section 23(2), which says that teacher at the time of commencement of the act shall have to acquire the qualification prescribed by NCT. But the RCFC rule, the central government framed it on 9/4/2010. In the RCFC rule, in upholding that spirit, my lord will find 19. The 17, 18 are there. The 17 is also minimum qualification. 18 is relaxation of minimum qualification. Only the central government to relax on the proposal of the state government and examine the proposal, and thereafter by notification will relax. There is no such provision under the Act for exemption. Only relaxation is there. But then 19 is relevant. Why I am drawing the attention to the 19? Because their stand something different. We are prior to RCFC Act appointee. Therefore, the TET is not for us. I will bring to that because that is the contention I have replied in my reply up to you. 19, your lordship, kind have glance. The heading is acquiring minimum qualifications. Rule, my lord. The state government and union territory shall provide adequate teachers' education facilities to ensure that all teachers in the school referred to in subclause I and school owned and managed by the central government or state government or union territory or local authority under subclause 3 of clause N of section 2 who don't possess minimum qualifications laid down under sub-rule 2 of Rule 17 at the time of commencement of the Act to acquire such minimum qualification within a period of that was 5 years, and it has been reflected here is 9 years after 2017 amendment came into force into the Act. Because by virtue of 2017 Amendment Act, the proviso, the earlier stipulation of 5 years to acquire qualification was extended to by adding 4 years. That is 9 years. That has been carried in this bare act manner. Then it makes it clear, teacher who don't possess the minimum qualification laid down under sub-rule 2 of the Rule 17. That means 17 is consonant with that, the section 23. Who don't possess minimum qualification laid down under sub-rule 2 of the Rule 17 at the time of commencement of the Act to acquire the qualification. But this is the parameter provision is also available in the Orissa RCFC rule. That is available in book from the education manual. May I just read in light of Malad, 17. Malad. Acquiring minimum qualification. Government shall provide adequate teacher education facilities to ensure that all teachers in school referred to in subclause I and schools owned and managed by the central government or the state government or local authority under subclause 3 of clause N of section 2 who don't possess minimum qualification laid down under subrule 2 of the Rule 15 at the time of commencement of the Act. To acquire such minimum qualification within a period of 5 years from the commencement of the Act. That has been also enhanced because of the central government, the parliament being an amendment in the year 2017 by extending that 5 years limitation, which was ended by 31st 2015, March 2015, that was extended to 31st March 2019. And accordingly, my lord will find that I have also quoted, I have also in this bunch of the spiral, the binding, I have given the amendment. Parallelly, before commencement of that RCFC Act and the rules, NCT had the NCT Act, which was governing the field, prescribing the standard of education and also the qualification. 2001 regulation was framed, and what happened after commencement of this RCFC Act? NCT Act was amended in the year 2011. My lord will find that NCT Act that I have made available, that is at page 70, my lord, of the spiral binding. I have given all the documents, even they rely, we also rely. All the documents I have attempted to bring to your lordship's notice, since it will govern at least lakhs of teachers' fate, my lord, in the Odisha. But at page 70, my lord, this is National Council for Teachers Education Amendment Act 2011. But by virtue of this amendment, your lordship will find just 71 page. But may I draw your lordship's kind attention 6. After section 12 of the Principal Act, the following section shall be inserted, namely, that is 12A, for the purpose of maintaining standards of education in schools. The council may by regulation determine the qualifications for persons for being recruited as teachers in any pre-primary, primary, upper primary, secondary, senior secondary or intermediate school or college by whatever name called, established, run or aided or recognized by central government, state government or local authority, other authority, provided that nothing in this section shall, although they have not relied, but I want to bring to your lordship kindly, shall adversely affect the continuance of any person recruited in any pre-primary, primary, upper primary, secondary, senior secondary, intermediate schools or colleges under any rules, regulations or order made by the central government, a state government or a local authority or other authority immediately before the commencement of the NCT but Amendment Act 2011 solely on the ground of non-fulfillment of such qualification as may be specified by the council. But the proviso is important. Page 72. Provided further that the minimum qualifications of a teacher referred to in the first proviso shall be acquired within the period of specified in this act or under the Right of Children to Free and Compulsory Education Act 2009. That he referred the proviso of the RCFC Act. This amendment was necessitated after commencement of the RCFC Act so far the elementary education is concerned. My humble submission before Lordship is, which I on the first occasion, since they had not made any submissions, confined to section 23 proviso, first proviso and second proviso, and also confined to the relevant the RCFC rules and the central RCFC rule and state RCFC rule. Here, I rely on how the proviso of stipulation covers the teachers at the time of commencement of the act. That RCFC rule says they have to acquire. Who don't possess the qualification, teacher on the date of at the time of commencement of that, who don't possess the qualification, they have to acquire. Orissa rule also framed that says in the same manner. And even the NCT Act, which was amended, but that says by proviso, they have to acquire the qualification. But they may continue notwithstanding the qualification. But the statutory obligation is they have to comply the qualification as prescribed by the NCT notification dated 23rd August 2023. The second fold of submissions which I had submitted by relying upon the A.B. Krishnan judgment and also Patna High Court judgment. The impugned order, I have not just refresh the memory. Impugned provision is 97 cadre rule was amended in 3 phases that I have given in the compilation. In 2009 it was amended, 2014 it was amended, and 2019 it was amended. But by virtue of that amendment, 611, Rule 6 and 11 and Rule 15 was substituted. And in 15(2)(d) proviso, it was provided that teachers appointed prior to 11 February 2011, they are exempted from the TET qualification. That provision is under challenge. And even the Rule 6 of the elementary cadre rules, your Lordship will find that also I have enclosed in this spiral binding. That is at page 95. Page 95. Although I have quoted in my the compilation of the rules and regulations. At page 101, from the bottom portion, the second paragraph, provided that the teachers appointed against the advertisements published prior to 11/2/2011 are exempted from passing Orissa Teachers Eligibility Test 1 and Orissa Teachers Eligibility Test 2. And that is under the challenge. My humble submission was that in RCFC Act, neither the RCFC Act nor the RCFC rules, central or state, nowhere provide empowering the state government to bring exemption. Only RCFC Act rules both says regarding the relaxation. Relaxation that is subsection 2 of section 23, that says central government will only have the power to relax upon receipt of proposal from the state government. Therefore, bringing a exemption provision by the state government in exercise of power under Article 309 proviso is, my lord, it suffers from legislative incompetence. That was my first ground of assailing the order, my lord. Then second is, my lord, that since the rules, the Act, Central Act and rules, even the Odisha rules, read with 23rd August 2010 qualification as prescribed by the NCT, is governing the field, is prescribing TT that is occupied by the legislation which has been duly recognized by the state rules, so also central rules, and that cannot be overridden by any power exercised under 309 proviso. That is hid by the principles of, as your lordship also initial occasion that the Patna High Court judgment pointed out. Patna High Court judgment basing upon that principles of occupied field, A.V. Krishnan Malad, was the Bihar Rule 4 of the, which given an expansion providing competency test. No, you cannot be, court said, Patna High Court, you cannot provide a competency test in place of TT. When the Central Act already governing the field providing a TT is the essential qualification, then state government has cannot prescribe a different examination, competency test. Therefore, that was passed. That I had, other day I had placed, but in gist, these are the grievances. Then the further submission, my lord, which I had developed, that the petitioners from the beginning, my lord, they are with academic qualification, training qualification, and TT pass, my lord. Even the yesterday batch which had come, but that the teachers also the possessing the TT qualifications. What happened by virtue of this impugned exemption provision? Well, exemption provision, all the non-OTT, that means the underqualified persons, they are getting promotions from one level to another level. But let me, before going to that, let me kindly turn to the elementary cadre rule which was governing the field. That is page 1. Page 2 may kindly have a glance. Page 2 of my spiral binding. Page 2, that the constitution of service of the elementary cadre service, which is being followed, it was the 5 levels, but now it has been by virtue of the 2019 amendment 6 levels. Your lordship will find service shall comprise of the following levels, namely Orissa Elementary Education Service level V and Orissa Elementary Education Service level IV. Well, Orissa Elementary Education Service level 3. Orissa Elementary Education Service level 2 and Orissa Elementary Education Service level 1. Well, your lordship will find the eligibility for direct recruitment. I will come to their point, but I have categorically replied in my reply affidavit. Eligibility is, but they have to fulfill all the conditions. But at the page 4 is, he must have HSC pass and have completed so and so. And your lordship will find they have to be selected. All the initial level of 5 is to be filled up by direct recruitment, and the level IV to 1 is to be filled up by a promotion. This is being followed. Well, your lordship will find that I am just drawing your lordship's kind attention to the 2014 amendment of the elementary cadre rule 73, page 73. This 2014 cadre rule was amended. But why I have enclosed this? Well, I want to draw your lordship's kind attention to page 80, last portion. That explanation 1A was added to in 2014. All persons now working as primary school teacher under Jilla Parishad, my lord, kindly mark, my lord, having requisite training qualification, that is CT or B.Ed, shall be treated as member of the level 5. But prior to insertion of this provision, all the teachers, they were not the level 5 cadre teacher, my lord. They were Swachhasevi Shiksha Sahayak, that's a volunteer under the Sarva Shiksha Abhijan scheme, my lord. And after completion of that, the circular, that the entire development as I have given, after completion of 9 years in total, 5 years completion junior teacher, thereafter 4 years to be the teacher under the Jilla Parishad cadre, because it was transferred to the Jilla Parishad. Then, my lord, what happened? That 5 years and 4 years was further subsequent resolutions that I also enclosed, that was amended to 3 years and 3 years. Within after completion of 6 years, one will be teacher, but under the Jilla Parishad. They were not the teacher of level 5 till 2014 amendment by virtue of this clause. And by the time they were come over to this level 5 cadre, they had no also the OTT pass qualifications. And that is the grievance of the, one of the grievance, that we are appointed as teacher. It is not correct. I have shown, your lordship, my lord, your lordship will find page 9. Page 9 is the first resolutions. Your lordship will find, that is 310/2000, clause 4, my lord. Swachhasevi Shiksha Sahayak is a scheme for volunteers, 4.1. And those who accept the terms and conditions offered to render voluntary service would be engaged as such. And following that, my lord, your lordship will find in 2000, I have given on the chronologically, my lord, in 2001, NCT regulation came. All over India, prescribed the qualification of senior secondary, my lord. My lord will find by that time, HSC, Odisha rule, my lord, elementary cadre rule, prescribed HSC, whereas he prescribed the senior secondary, my lord, the qualifications. But in subsequently, your lordship will find in 2006, the engagement of Shiksha Sahayak, Swachhasevi Shiksha Sahayak, their designation was changed to the Shiksha Sahayak. And engagement of Shiksha Sahayak will be made by the Jilla Parishad as per requirement under the program of elementary education and Sarva Shiksha Abhijan. They were all recruited as volunteers and even as a Swachhasevi Shiksha Sahayak or Shiksha Sahayak under the Sarva Shiksha Abhijan scheme. And their placement was made under the Jilla Parishad, not under the level 5. And for the first time in 2014, they come over to the level 5 cadre.
That you told. Yes.
And
Don't repeat.
that, my lord, at this juncture, my lord, I want to my lord, come to my reply affidavit, my lord. And may kindly read the reply affidavit.
No, not the entire affidavit, only the portion you want
But
to
I have made it on specific answer. My lord. My lord, I beg apology for my younger juniors, my lord, your lordship. I beg apology for my younger juniors.
No problem. After that, he will address, so don't worry. Yes.
My lord. My lord, that the reply affidavit para 1, my lord. In reply to the first contention regarding clause 4 and 5, may I draw the attention to the clause 4 and 5? Thereafter, what was their submission? That defend, my lord. And what is my lord? Clause 4, 5 of that 23rd August 2010, my lord, that is the NCT notification prescribing qualification. That is, here is available at page 49. Can't have a glance. 49. They but as at page 51, my lord. At page 51. My lord, Lordship, with embarrassing situation, my lord, I am making because of my young brothers.
Carry on, carry on.
My lord. My lord.
May I beg apology, my lord?
Please take your seat.
Yes.
My lord, page 51. Teachers appointed before, what they my lord, heavily reliant, and that is my answer. May I want to just refresh the memory what was their submissions, my lord. Teacher appointed before the date of notification. The following categories of teachers appointed for classes 1 to 8 prior to date of this notification need not acquire the minimum qualification specified in para 1 above. Para 1 is that qualification of TT with the training and academic qualification. And teachers appointed on or after 3rd September 2001, the date on which NCT determination minimum qualification regulation 2001 came into force in accordance with that regulation. But it clarified that teachers those are appointed after 3 September 2001, that is the NCT regulation. If they are appointed in terms of that regulation, they may get the exemption over and above. 2001 regulation says the secondary teachers must be possessing the secondary the certificate. But they were not appointed as teachers. That is my first submission. Second, they were appointed under the Sarva Shiksha Abhijan as volunteers, and their placement was under the Panchayat. Following that 73 amendment, the Jila Parishad Manaj, and they were continuing as Shiksha Sayak or teacher even after completion of 6 years or 9 years under the Jila Parishad Manaj. They had never come over to the level 5 cadre. Cadre they came into force in the year 2014. By the time this RCFC Act and rules regulations were governing the field. And my lord will find the subsequent notification, they also relied the same provisions 4 and 5, which says teachers appointed prior to commencement of the act, but in accordance with that 2000 NCT regulation bearing the qualification, then they can get that exemption. Here the first submissions they have, what the ground they have taken, that basing upon the para 4 and 5 of the NCT notification dated 23rd August 2010, that they are exempted. They are not required to acquire the TET qualification, and that is why they have been given the exemption provision under the Elementary Cadre Amendment Rule 2019 is intravirus, not ultravirus, and this para 4 and 5 of the NCT notification dated 23rd August 2010 will govern the field. But the proviso of section 23 will not be given effect, will not stand as a bar. section proviso to section 23(2), which says teacher at the time of commencement of the act, has been supplemented and more explicitly cleared from the rule 20 of the RCFC rule, my lord, central RCFC rule, and 17 of the RCFC rule. The teacher don't possess qualification at the time of commencement of the act shall have to acquire the qualification. Even NCT Act section 12A mandate that they have to acquire the qualification. Therefore, my humble submission before Lordship is to the first contention, para 4 and 5 will not take away or nullify the statutory provisions of the Principal Act and the 2017 RCFC Act amendment, and so also the rule 20 of the RCFC rule and rule 17 of the RCFC, the Orissa RCFC rule, which mandate teacher on the date of commencement of the act, at the time of commencement of the act, they have to acquire the qualification. Therefore, 4, 5, I have answered in paragraph wise. My lord will find. Para 4, which prescribed that teachers appointed prior to notification dated 23rd August 2010 need not require to qualifications, is contrary to the statutory proviso to section 23, also contrary to 19, rule of the 2010, 17 of the RCFC rule, and the para 4 giving declaration that teacher appointed prior to notification dated 2010 need not acquire minimum qualification is also violative of section 8A and G. That's the second answer that I have given. And para 4, so far declaration not to acquire qualification also runs contrary to the section 21A. Because in Devesh Sharma's judgment, my lord, I have already taken note of in our High Court, in a division bench judgment, my lord, that the right to act, right to education under the RT Act, my lord, includes the right to quality education. My lord, these are the grounds I have taken, my lord. Regulation, my lord, the subsequent ground that I have taken also, even assuming for the sake of argument, that 4 and 5 enables them not to acquire qualification, that is also with rider. They would have been appointed in terms of NCT regulation 2001. They have not been recruited following the qualification of 2000 regulation 2001. My lord. They were volunteers and they are Sikha. And they even after 6 years of completion, earlier it was 9 years, 6 years of completion, they became teacher under the Jila Parishad. They had not come over to the level 5 cadre. Therefore, this para 4 and 5 contentions they have raised, my lord, I have denied in this way. Then, my lord, the second contention they have raised, my lord, in reply to second contention regarding the interpretation of the word recruitment and the word level, my lord. My lord, that in order to give my humble answer in respect of the level, my lord, that my lord, come from NCT regulation 2014. NCT regulation 2014, my lord, that I have enclosed in my this spiral binding, that is page 81, my lord. Page 81, 82, my lord. My lord, 82, that para 4, that the NCT regulation says qualification for recruitment. A deals with the appointment, qualification for recruitment, and B deals for promotion the teachers of relevant minimum qualification as specified in first and second schedule are applicable for consideration from are applicable for promotion of teachers. The relevant minimum qualification as specified in first schedule and second schedule are applicable for consideration from one level to the next level. And here the first schedule says the name of academic and professional qualification level. they took the view, their contention, bone of contention is the word label is confined as given in the schedule and in the notification. Since they have used the word label, that is, label means label of pre-primary, upper primary is one label. Secondary, then the primary of, then my lord, your lordship will find primary, upper primary is one level. Secondary high school is one level. College is another level. Therefore, any person appointed in primary schools teachers, if he seeks the, by virtue of, he seeks the promotion to the high schools, then the high school qualification is applicable. If further promotion he wants to the college level, then in terms of this interpretation, my lord, as the advanced label means as label indicated in the schedule, then the college qualification is required to be acquired, my lord. My humble submission before lordship is that I have given in my reply in detail, point wise, my lord, that your lordship will find but first I have related the recruitment. Recruitment word as used in the regulation, that recruitment under the rule 4 of regulation 4 of the regulation 2014, that includes at page 5 of my reply affidavit, by way of appointment or by way of promotion. But the label, with regard to label, that I have also quoted the provision still date governing the field. The elementary cadre rules, rule 3 prescribes these labels, which I have reflected. For 1 to 6 levels, up to 6 levels. Level VA, level VB, level IV, level 3, level 2, and level 1. My humble submission before lordship is, label as used in 4B, that's label word may not be read isolatedly from the word promotion, because that wording B says for promotion, teacher from one level to another level has to possess the qualification as per the schedule. That means promotion label is to be read together, and label may not be read isolatedly, and that means the promotion label which is available in terms of the service condition rules. Here in the service condition rule, as it is governing the field with amendments, that is the 6 levels. Therefore, here the interpretation of label, if will be accepted, their contention will be accepted, then teacher appointed yesterday in primary schools from 1 to 5, 1 to 8 class, if in the event he will seek promotion to high school, then he has to possess the high school qualification. Next promotion to college, then college qualification. But that the label word used in the schedule is in the sense of category, and it is in 4B use the label that is promotion label. Promotion label within the cadre. Here the cadre is 6, the constitution of the 6 cadres. Within that, when he will travel his career advancement, then he has to acquire the qualification which was required for the direct recruitment. That the recruitment qualification is as telltale, that is not in dispute from 23rd August 2023. With regard to label, this is in nutshell that I have given answer. In the paragraph 2 of my reply. Then, with regard to the third contention, it is available in my page 7 of my reply affidavit. In reply to the third contention raised by the interveners and respondents of the writ appeals, writ appeal was filed by the government challenging the judgment of the single judge. The honorable single judge granted taking note of that exemption provision, yes, granted that their promotion is to be made. But that has been challenged by the state government on the ground that cannot be done, it is runs contrary to the 2017 RCFC Act, Amendment Act, which mandate that they have to acquire the qualification by 31st March 2019. But in reply to this bill, it is only submitted that small a, the preamble of the bill unambiguously project the legislative intention bringing such amendment, which inter alia prescribed that the bill seeks to amend the RCFC Act 2009 by extending deadline, kindly mark, for teachers to acquire the prescribed minimum qualification for appointment. It only extends the deadline which was available under the first proviso to section 23(2), that within 5 years they have to acquire. Teacher at the time of commencement of the act have to acquire. That was extended by 2017 amendment to 2009. Then B, the deadline as was fixed under the second proviso to so and so was already expired by this, causing hardship to both categories of teachers appointed at the time of commencement of the act and teacher in position. But the language 17 amendment used the teacher and teacher in position. For them 4 years was granted. Therefore it covers all. Therefore my humble submission that I have extended the meanings. That my humble submission is that the bill which projects the as in a preamble which projects the intention of the legislature or legislative, that clearly shows the deadline which was earlier fixed, that has required to be extended, and accordingly 2000 following this bill 2017 amendment came by granting 4 years, not 2 years. But any persons even required to acquire is to acquire within the 4 years the qualifications, T2 qualifications, also other the qualifications. But with regard to the other contentions, that I have at para 4, that the fourth contention that I have mentioned. That in reply to fourth contention as pleaded in their intervention application at paragraph 8 and 26, that impugned exemption provision under proviso to Rule 15(1)(d)(2), Rule 11, Rule 6 of the Elementary Cadre Amendment Rule 2019 is not ultra-virus. They want to say exemption provision is intra-virus. Ultra-virus does not violate the provisions of any central act or the provisions of the Constitution, is not at all sustainable, tenable for the following reasons I have given. That the reason is that the amendment rule, particularly that provision, not the entire amendment I am going to say. We are aggrieved by that exemption because we are all the teachers in thousands, around 80 or 85,000 teachers, they are with the T2 qualifications. And they are being marched over by the 2010 prior appointee, or 11 to 2011 appointee, because of that exemption provisions without having T2 qualifications. And B, even the section 2, so and so, that I have given the reasons, and Rule 19 and etc. that I have already placed. That even the proviso leaves no doubt that it does not cover the teachers appointed or in position at the time of commencement of the act. Otherwise, the rule which came after the act came into force, section 23(2) and first proviso, that makes it clear a teacher at the time of commencement shall have to acquire. Even Odisha rule also says so. And even section 12A of the NCT Act amended made in the year 2011, that also says so. Exemption can be for their continuance, not for the it does not mean that they are escort free from the obligations, all these provisions. That I have given 4 to 5 or 6 reasons, A, B, C, D, E, And E, the other contentions of the intervention extend that they are wholly exempted, being prior RCFC appointees, page 10, are also not tenable, sustainable, because all the interveners were never appointed under the unamended provisions of the Elementary Cadre Rules 1997. Because there is no appointment at all directly facing the examination, written examination. And my lord, they were all appointed as volunteers under the Sarva Shiksha Abhijan. And their placement was under the Jila Parishad. In 2014, they came, my lord, in respect of the Shiksha Mitra's case of the UP, my lord, 174 teachers, those who are come over to the regular status, my lord, court said no, you have to acquire possess the minimum qualifications, my lord. And my lord, here that the region I have advanced, my lord, they became junior teachers thereafter, regular teacher under Jila Parishad cadre in terms of the GO of 14/11/2017 on 9 years and so and so. That I have, my lord, explained. And even the 2014 amendment that I have taken note of. My lord, with regard to, my lord, today's, I feel, my lord, feel sorry, my lord, because judgments are there. My lord, in 10 years back in 2014, had an occasion while sitting in, my lord, along with the Honorable Acting Chief Justice Ansari, treating with the very qualification of TT, although that was relating to regarding the awarding marks, my lord. That, my lord, in paragraph 8, my lord, stated something, how it measures the national standard, why it is essential, my lord. Therefore, the quality and merit is required to be, my lord, preserved because that is the mandate of section 8G, 8A and G, which ensures that state and union territories shall have to ensure quality education. And Devesh Sharma's judgment, my lord, that shows is amply clear, my lord. Although I have brought judgment, 10 to 15 judgments, because if you lordship, in this situation, my lord, I afraid of to place all these things, my lord. I feel, my lord, if, with regard to all regards, my lord, I know, my lord, what is our sides, my lord, when the senior counsel is begging a time, my lord, and my lord, at that juncture, at least he is pretty junior, he could not have objected, my lord. And that is why I was praying that yes, the date may be fixed, my lord. All the judgments are with me, but I want to give it through a spiral binding that my lord's judgment in 10 years back, my lord, that's your, my lords have visualized what is the importance and significance of TT. And in the meantime, my lord, the Patna High Court, even competency test Bihar government prescribed. That said, no, it cannot be because TT is there. In Madras High Court also, they say no, TT is essential for promotions. They may continue. For continuance, they may not, but they cannot get promotions, my lord. Even if lordship, there are judgments, but if lordship will permit, my lord, the other day let them keep their answer, my lord, I will only cite judgment on that day, since my senior after giving reply to this my reply affidavit, thereafter I will be permitted only to place the few judgments, my lord. This is my humble request, my lord, because it will deal with the at least 1.5 lakhs teachers' fate, my lord. Either the way, my lord. Everybody expecting, my lord, it will settle the positions where the and thousands of disputes, my lord, which is pending before High Court, my lord, it will be immediately reduced. Let them, my lord, the other day they'll let them submit their answers. Thereafter, I will keep only few minutes, my lord, 2-3 minutes, and I will place all the judgment, not today, my lord. Only this is my request, my lord, earnest request. Let me time allowed to my, because the seniors, and in many respect, we are many of our learn from our seniors, my lord. When senior is begging time, we should not stand on the way, my lord.
Is that all?
My lord.
Just take. Yes. Anyone else?
I beg pardon, Your Lordship. Before starting my argument, I beg pardon, Your Lordship.
No.
Your Lordship, on the last occasion, Your Lordship, on dated 21/8/2024. Your Lordship, there is a order of Your Lordship that A submission may I place your lordship. A submission has been advanced on behalf of the interveners that the requirement to acquire TET qualification as stipulated under the second proviso to section 23(2) of the Right of Children to Free and Compulsory Education Act 2009 applies to such person only who did not have the minimum qualification as laid down by the academic authority authorized by the central government by notification under section 23(1) thereof. They have relied on Gazette notification dated 23/8/2010 issued by the NCTE paragraph 4A, of which contemplates that certain category of teachers appointed under class 1 to 8 prior to the date of notification need not acquire minimum qualification specified in paragraph 1 of the said notification, and thereafter, your lordship, they relied upon the bill, your lordship, that is on para 4, your lordship, that the interveners have submitted that for just interpretation of second proviso of section 23(2) of the act, this court may take aid of highlights of the amendment bill 2017, which is part of the legislative note, and that they may be permitted to file affidavit along with the documents relied on by them. Lordship, in pursuance the your lordship, this order, they have filed an affidavit regarding that such notification is only applicable for those required for appointment and not for the promotion, lordship. Lordship, so far as section 23 is concerned, your lordship, may I permitted to place, your lordship. Section 23 speaks about qualification for appointment and terms and condition of service of teachers. Section 23(2), your lordship, where state does not have adequate institutions offering courses or training in teacher education or teachers possessing minimum qualification as laid down under subsection 1 are not available in sufficient numbers, the central government may, if it deems necessary by notification, relax the minimum qualification required for appointment as a teacher for such period not exceeding 5 years as may be specified in that notification. Your lordship, in this the appointment, lordship, there is a specific judgment of Honorable Supreme Court that the appointment also includes promotion, your lordship. May I place, your lordship. Your lordship, that is 2006 to SCC 482, your lordship. Paragraph 12, your lordship. May permitted to place, your lordship. Article 16, which finds place in part 3 of the Constitution relating to fundamental rights, provides that there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in public offices. The words employment or appointment cover not merely the initial appointment, but also other attributes of service like promotion and age of superannuation, etc. Lordship. Thereafter, your lordship, so far as promotion is concerned, your lordship, there is another decision, your lordship, by Allahabad High Court, your lordship. Kind. Division bench, your lordship, that is paragraph 5, your lordship, where of the may please, your lordship. Election, promotion, and for any other mode of appointment, and it is not confined only to the selection for open recruitment. We therefore find no reason to restrain respondents from taking aforesaid test. The purpose of having a person pass TET is only to judge one's efficiency and performance of imparting education primary school. In case teachers are not efficient to impart primary education to students, the very purpose of providing basic standard education would be defeated, Your Lordship. Your Lordship, thereafter, Your Lordship, another decision of the Honorable Supreme Court, Your Lordship. In state of Maharashtra and others versus Madhukar and others, etc. Lordship, second page, Lordship. Law and Counsel for the petitioners submits that the respondent do not have teachers eligibility test qualification, which is an essential eligibility criteria of appointment as primary teachers. Mr. So-and-so Law and Counsel for the respondent submits that the respondents were initially appointed prior to the Right of Children to Free and Compulsory Education Act 2009 came into force, and the educational qualification as contemplated under the Act are not applicable to the respondents. We do not agree with the submissions made by the Law and Counsel for the respondents. We direct the respondents who are appointed and regularized as primary teachers to complete the TET qualification within a period of 5 years, in default of which the state government shall terminate their services. Your Lordship. Your Lordship, thereafter another decision of Honorable Bombay High Court, Your Lordship. Paragraph 11, Your Lordship. Paragraph 11. Since all the petitioners covered by all orders of this court are apprehending termination of their employment, it is for the appropriate and competent authority to devise a measure so as to consider their version. We are not going to direct the government to do so once we have noted in the foregoing paragraph the purpose of the policy. If there is a direction from the National Council of Teachers Education and Department of Human Resources Development, Government of India, then all the more we are not going to allow the state government to deviate from the rigors of the same. If that includes termination of employment, then it is entirely for the state government to explain as to why it was and is reluctant to enforce the scheme of the central government. Lordship. It is the state government which must explain to the teachers why it relaxed the rigor of this condition, which is otherwise fair, just and reasonable. It is then the state government which must explain to them as to why it is no longer in a position to bear the financial burden. We do not think that the petitioner can call upon the High Court to explain all this to them, and we are of the firm opinion that none of the petitioners have a vested or fundamental right to question such policy, Your Lordship. Thereafter, in the circumstances in the case of these teachers who have appeared for examination to obtain the qualification TET, until the results of the same are declared, their appointment should not be terminated. The petitioner must realize that they have no right to continue if they fail to clear the test, and they cannot dictate to the government or to the court that no such test should be held or even after the cut-off date. Their jobs should be protected if they do not attain this qualification. Your Lordship. Your Lordship, thereafter the decision of the Honorable High Court of Madras, Your Lordship. Your Lordship, paragraph 43, Your Lordship. At the risk of repetition, it must be stated that while the NCT notification had clearly protected those who had already been appointed prior to the date of the notification from passing TET, there is nothing in the said notification which affords an exemption from passing TET when they aspire for fresh appointment by way of direct recruitment, promotion, or otherwise to post of graduate teacher, Your Lordship. The principle of interpretation that when the language of the statute is clear and unambiguous, it is not for the courts to substitute their opinion or inject their philosophy into the provisions. It's a trite law and the same is to be applied, Your Lordship. The principle of literal interpretation would lead to the inevitable conclusion that only those who have been appointed prior to the date of issuance of NCT notification are protected and exempted from passing TET for continuance in the respective post against they have been appointed, Your Lordship. Hence, we conclude that those appointed prior to 29/7/2011 and in order to extend the benefit to the date of passing government order such and such, those appointed prior to that date, either in the post of secondary grade teacher or graduate teacher or BT assistant, are exempted from passing TET for continuance in the said post, not for promotion, Your Lordship. However, for promotion to the post of graduate teacher, for the post of secondary grade teacher, or appointment to the post of secondary grade teacher or graduate teacher by any channel or mode of appointment by either direct recruitment or promotion or by transfer, a pass in teacher eligibility test is mandatory in accordance with RT Act, read with the NCT notification, Your Lordship. And thereafter, Your Lordship, in the result, the writ petition challenging the virus of the impugned special rules are hereby allowed, and the special rules for the Tamil Nadu School Education Subordinate Service issued government order such and such, in so far as it prescribes a pass in teachers eligibility test only for direct recruitment for the post of BT assistant and not for promotion thereto, annexure 1 is illegal, being ultra virus the right of children to free and compulsory education act 2009 and the rules framed thereunder and the NCT notification dated 23/8/2010 and 29/7/2011. Lordship. Lordship, my only humble submission, Lordship, that TET is mandatory to remain in the service, Your Lordship, also, Your Lordship, and for promotion also TET is mandatory, Your Lordship. Your Lordship, so far as the notification, Your Lordship, 2014 is concerned, Your Lordship, that the label, Your Lordship, 4, qualification for recruitment, Your Lordship. For promotion of teachers, the relevant minimum qualification as specified in the first and second schedule are applicable for consideration from one level to next level, Your Lordship. Your Lordship, as per the decision of Honorable Supreme Court, Your Lordship, in Devesh Sharma, Your Lordship, this label is divided into two categories, Your Lordship, primary and, Your Lordship, upper primary. That is 1 to 5, the primary, and upper primary, that is 5 to class 8, Your Lordship. And for the quality education, Your Lordship, TET is mandatory, Your Lordship. And so far as the rule is concerned, Rule 15 of the cadre rule, Your Lordship, Rule 15 provides, Your Lordship, that is the provided that teachers appointed against the advertisement published prior to 11/2/2011 are exempted from the passing of OTET 1 and 2. Your Lordship, exemption means, Your Lordship, total immunity, Your Lordship. So far as relaxation is concerned, that is only temporary remission, Your Lordship. And here the exemption has been given by the state government, Your Lordship, in contravention with the RTE Act, Your Lordship. And so far as writ appeal is concerned, the government has filed writ appeal against that such promotion is concerned, Your Lordship. That's the for promotion, Your Lordship. The TET is mandatory, Your Lordship. Page 12, Your Lordship, kindly have a glance of that writ appeal number 1344 of 2024 filed by the government, Your Lordship. In page 12, may permitted place. But those who have, Your Lordship, that is from the last, Lordship, bottom, Your Lordship, bought those. But those who have acquired higher qualification after 11 to 2011 and exercising their option to become graduate teachers have passed OTET 2, they shall be placed in gradation list of teachers with a bachelor degree below the existing teacher, taking into account the date of passing OTET 2, Your Lordship. So the government also challenging, Your Lordship, so far as the TET is concerned, that is for promotion, Your Lordship. TET is mandatory for promotion. And on the last occasion, Your Lordship, specific query was how you become aggrieved. We become aggrieved because they are without having TET qualification, they are getting their promotional avenues, Your Lordship, and they are promoting to the graduate teacher, Your Lordship, having less qualification than us, Your Lordship. That's all. Obligatory.
My lord, I apologize. I have prepared a short written notes, and I have served this the opposite parties counsel my lord. So in the first, I have only to produce before lordship. Now the before lordship has directed to serve in the court. So my lord, only because I beg apology, and I may also take time on the next date, I will, my lord, start my argument.
There is not going to be a next date.
My, if your lordship,
This you can take, please.
My lord.
We are sitting in the second half. We will conclude the hearing of this case. Therefore, there is not going to be a next date.
Okay, my lord. I'll serve the copy of this, my lord. Your lordship, may I be permitted to produce the written notes which I have prepared before lordship. My lord, this is the, and I was mixing somewhere. I'll start. My lord, only the crux of the case. There is the amendment rule 2019. This is proviso, that is 11 under rule 11 proviso and 15B1 proviso. That is, I have challenged that is that should be declared as a ultra virus, because that is the only the with regard to the qualification, that is the exempted by the state government in the amendment. This is amendment rule 2019. The initial the rule 97 rule has been amended. So my lord, in this crux of the case, only whether the that is the qualification should be considered at the time of recruitment or in the time of promotion. That is the only the point to be decided here, my lord. Only I beg to draw lordship's attention to the 97 rule. That is the 97 rule, your lordship, that is the Odisha Elementary Education Methods Recruitment Condition of Service Teachers and Officers Rule 1997. My lord, if your lordship peruse for a moment, there is the 1997 rule. This is the Constitution of Service at rules 3. That is the elementary education service level. This starts from level B and ends with the level 1. And the promotional facilities, that is the 11th. At rule 11, the eligibility for the promotion, it has been specifically stated, in order to eligible for the promotion of this post belonging level 4 of the service candidate must have served for continuous period of 8 years in the post belonging to level B. Means a person, a teacher, should be promoted from the level 4 to level B, 5 to level 4. In this process, my lord, the level 3 likewise. In this rule is specifically stated, my lord, in 1997 rule. And the 1997 rule, my lord, some parts has been substituted in 1999 rule, 2019 rule, but not superseded. This rule has never been totally superseded. Only some part of this is the clause, there is a some rule, sub-rule or rule has been substituted. That is the which we have challenged. That is 15D proviso, 1 proviso, as well as the 11 proviso. With regard to these, we are saying the TET qualification is mandatory because they are central government. They framed a rule. It is a 2000 framed. They enacted an Act 2009. That is the Right to Free Compulsory Education Act 2009. Only to impart the education to these two children from 6 to 14 years, and also some, that is the eligibility criteria for the teachers have been prescribed by the, that is the academic authority, which is, that is the power conferred to the academic authority, which is the highest authority of for the academic, that is the NCT. That NCT has prescribed the qualification. If the your lordship only to draw your lordship's attention to the, that is 23 section 23(2), that is the qualification prescribed by the NCT, which is, that is the that should be introduced from the commencement of the Act. From the commencement of the Act for the all purposes, for the recruitment as well as the promotion. Your lordship, may I bring lordship's attention? That is already Mr. Sahu has also drawn attention. That is the 23(2). That is it is admitted. That is the qualification has been prescribed by the, your lordship, come to mind. That is the read petition. Read petition, page number 63. Annex 3, my lord, this is the my read petition number 21547 of 2023. That is page 63. There is the NCT notification. May I be permitted to read this, my lord? This is new, that is 23rd August 2010. The in exercise of the power conferred by subsection 1 of section 23 of Right of Children Free Compulsory Education Act 2009, and in pursuance of the notification number so and so issued by the Department School Education Literacy, Ministry of Human Resource Development, Government of India, the National Council for Teachers Education NCT hereby lays down the following minimum qualification for the person to be eligible for appointment as teachers in class 1 to class 8 in a school referred to the clause N of the section 2 of the Right of Children's Free Compulsory Education Act 2009 with effect from the date of the notification. That is the minimum qualification for class 1 to 5. That is all the qualifications mandatory. Your lordship see, that is the or and your lordship given, that is the end. The word end, the pass in teachers eligibility test, not or, my lord. It is all the qualification, senior secondary at least 50% marks, or that is senior secondary 45 marks, likewise or. But which is mandatory, that the end, the pass the teachers eligibility test to be conducted by the appropriate government in accordance with the guideline framed by the NCT, and also class VI to 8, class 8. That is also the start, that is the mandatory, the last B, that is the A or, and the last end, pass teachers eligibility test to be conducted by the appropriate government in accordance with the guideline framed NCT purpose. The NCT is the highest, the apex body of the academic authority that is in the country, and all the state has to follow the principle and the guideline as the conferred by the Education Act, Central Act. That's why the only qualification has been framed, and nobody can deny that is the TET qualification is a must from on the date of commencement of this act. That is also it has been stated like so. So, my lord, in the rule, Odisha rule, your lordship see in the rule of the 2010 rule. May I be lordship 10 Your lordship see there is a 11, there is a 15 in the page 50 in the teachers. This is a Odisha rule which was also framed. That is the 2000. That is the Right to Free Compulsory Education rule. Odisha has framed a rule. That is part 6, page 50. Page 50, your lordship may see the minimum qualification for appointment of teachers in elementary school. That is the person to be appointed as a teacher shall be in consonance with the qualification laid down by the academic authority constituted by the central government. That is NCT. The minimum qualification laid down by the academic authority referred to sub-rule 1 shall be applicable for every school. Refer to clause N of the section 2, your lordship. That is the Indian. It has been stated like so. The acquiring the 17, this is the rule 17, acquiring minimum qualification, lordship, the same page. Government shall provide adequate teacher education facility to ensure that all the teachers in the school referred to sub-clause 1 and school owned and managed by the central government or state government or local authority under sub-clause 3 of clause N of 2 who do not possess the minimum qualification as laid down under sub-rule 15 at the time of the commencement of the act to acquire such minimum qualification within a period of 5 years. That is the rule, 2010 rule. It has not been superseded by this in the amendment rule, my lord. And your lordship, that is thereafter, my lord, the 17th rule, which is that is the amendment rule of also the further 4 years time granted to all the teachers to acquire the qualification. So it does not mean that any teacher shall be exempted from the TET qualification. It is a mandatory, it is a must by the central government. This is the central act as well as the state rule, my lord. So in the opposite parties are saying that it cannot be implemented in the case of the promotion. But in the promotion, that is the rule, 97 rule, and in 2009, 19 rule. Both the arguments also, that is the service condition, that is the also includes the promotion. So cannot be denied that if in the case of promotion as well as in the recruitment, the TET qualification is a must. Everybody has to follow, every teacher has to acquire the TET qualification always on the date of commencement of the act. But the teacher cannot be a teacher without any TET qualification. Only for the sake of my lord. So this is the decision of the LRC. My friends cited this Madras High Court also. This case, Patna High Court also raised this point. It was raised before the High Courts, and also this was confirmed by the Supreme Court. The TET qualification is mandatory, and it is if the TET qualification is exempted or relaxed, this is the ultra virus by any rule of the government of any state. This is the also, my lord, here said there are so many decisions, and it is also they have also given that is the reply, that is the citing in the writ of bill. That is a bill. In the parliament there is a bill for relaxation. This is how, my lord, the bill it is unless until it is enforceable by law. How this bill will be accepted, my lord? This is the I may be permitted to they have annexed, that is the legislative note in the Right of Children Free Compulsory Education Amendment Bill 2017. It has been written that for the use of members parliament, and then below it has been stated the legislation note is for personal use of the member of the discharge of their parliamentary duty and is not to publication. This service is not to be quoted as a source of information as it is based on unless until it is enacted, it is enforceable. How this one, and they are saying there is no whisper regarding this is a relaxation, exemption or the relaxation in the bill. Only they are saying that is the promotion. In the case of promotion, this cannot be accepted. How? This is the central act and the state rule. This is which has not been amended. State rule, this is active rule is still is existence, and the central act is still existence. And how my lord, the TET qualification and will be exempted, and that will be inserted in the rule 2019, and that is proviso in the proviso they have stated there is as on the date of 11/2/2011. Those citizens who have not acquired any TET qualification, they will be exempted for the once for all. How, my lord, this is the arbitrary point cut of date. This is the 11/2/2002. They cannot, the state government cannot. That is put how the death came, that is pointed out in that inserted into rule, my lord. These are because prior to that, these are rule. The act came into force 2009 and the rule came into force 2010. But they will be only the TET qualification will be introduced after 11/2/2011. This is the, my lord, this is the India Amendment rule they have been inserted. So your lordship, very, my lord, it is very openly it is seen that this is the ultra virus. Purely, my lord, is the against the principle, against the, my lord, that is the public interest, and the against the legislature, my lord. So here, this is the, your lordship may invoke the extraordinary jurisdiction 226 and to take the struck down these only the 15D proviso and 11, that is the 11 proviso, my lord. So I only beg your lordship attention to this, really because they have no, the opposite party intervener or the staff have no stand. That is that they cannot, only the promotion, this qualification applicable to the both in recruitment as well as in the, this is a promotion. So they cannot deny. So my lord, I will cite, only I will file the written notes of submission, because only if your lordship permit, then I can read. This is a very, that is, it will take half an hour only. If your lordship allow me to read the written notes of submission, then I can cite before lordship. Reminder, may I, that is, I may read this written notes. That first, that is the petitioner is working, my petitioner, who is working as a teacher in level VA in Ajodhya Nodal High School under the VO Nilgiri, Baleswar, and he has challenged the virus of the Odisha Elementary Education Methods Recruitment Condition of Service of the Teachers Amendment Rule 2009. With regard to the proviso Rule 15D 1 and Rule 11(1) proviso, which contrary to the Right to Pre-Compulsory Education Act 2009 and Right to Pre-Compulsory Education 2010 and Odisha Right to Pre-Compulsory Education 2010 and Gazette notification dated 23/8/2010 by the NCT. So the Amendment Rule 2009 consisting Rule 15D(1) and Rule 11(1) proviso resulting to violation of Article 14 and 16 of the Constitution of India, which creates anomalies, confusion, contradiction, discrimination among the category of the primary school teachers from class 1 to class 8 for appointment and promotion. So the petitioner has prayed for declaring the proviso Rule 15D(1) and the proviso Rule 11(1) of the Amendment Rule 2019 as null and void, and the same may be deleted. On the contrary, the letter of the Government SME Department 4607 dated 27/2/2023 is also declared as honest, and any promotion pursuant to these provisions and letters may be cancelled in invoking the extraordinary jurisdiction of the Honorable Court 226 and 227 and as per the settled principle of law by the Honorable High Court and the Supreme Court. The second, my lord, that the right of the children to Free Compulsory Education Act 2009 enacted with effect from 1/4/2010 envisaging free and compulsory elementary education for every child in the age group of 16 to 14 from class 1 to 8. Similarly, the power conferred under Article 309 of the Odisha Right to Pre-Compulsory Education Rule 2010 was implemented with effect from 27/9/2010 pursuant to the Right to Pre-Compulsory Education Act 2009. That under section 23(1) postulates that the academic authority, that is NCT, is authorized to prescribe the qualification for appointment and promotion of the elementary teachers from class 1 to 8, being the academic authority. Similarly, under section 23(2) in the proviso, that is, it is stated that the teacher who is at the commencement of the act does not possess minimum qualification prescribed under 23(1) shall acquire such minimum qualification within a period of 5 years. This qualification was relaxed for another 4 years. That is a relaxation, but not exemption. This is a relaxed for another 4 years as per the RT Amendment Rule 2017. It is pointed out that the NCTE, the NCT had specifically stated that in order to become a teacher in class 1 to 5, a teacher has to obtain +2 pass certificate with teacher's eligibility test certificate, pass certificate. Similarly, class 6 to 8, a teacher has to pass plus degree qualification with the teacher's ability test part 2. That the methods of recruitment condition of service teachers Rule 1997 being the cadre rule as amended as Odisha Elementary Education Methods Recruitment Conditions 2019, in which the government incorporated the proviso under Rule 15D1 that the teachers appointed against the published advertisement prior to 11/2/2011 are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teachers Eligibility Test 2. Similarly, proviso under Rule 15D2 that such senior teachers in level BB of the service exercising their option to become graduate teacher have passed Odisha Teachers Eligibility Test 2. They shall be placed in the gradation list of the senior teacher with a bachelor degree below the existing teacher, taking into account the date of passing the Odisha Teachers Eligibility Test 2, as well as the seniority in the merit list finalized for the promotion of the level PP of the service in the Amendment Rule 11(1) proviso. It has been incorporated that is 50% of the vacancies shall be filled up by the candidates having passed high school certificate, higher secondary +10+2 examination or graduation with secondary teachers training certificate, teachers course diploma in elementary education from the recognized board or university or equivalent thereof, and have passed Odisha Teachers Eligibility Test for candidate engaged in Shiksha Sahayaka or junior teacher contractual against the advertisement published 11/2/2011. They have quoted only 11/2/2011. This is artificial arbitrary date. There is secondly, 50% of the vacancies shall be filled up by the candidate possessing a bachelor degree in any discipline with secondary teachers training, certified teachers course, diploma elementary education, or bachelor in course or in equivalent examination and training course from a recognized board or university, and having passed Odisha Teachers Eligibility Test 2, that is for candidate engaged Shiksha Sahayak or junior teacher contractual against the advertisement published 11/2/2011. Always they are quoting 11/2/2011. How they have brought to this date? These are purely arbitrary. Pursuant to this amendment rule, the government tried to give promotion from level BB to level 4 and level 4 to level 3, and the Odisha Elementary Cadre by notification the number 4607 dated 27/2/2023, which is also under challenge in this read petition. This is also we have challenge, that is the 27/2/2023. They are going to, that is the give the promotion. That in exercise of the power conferred under section 23(1) of our Right to Free Compulsory Education Act 2009 and pursuant to notification of Ministry of HRD dated 31/3/2010, the NCT being the academic authority published the notification dated 23/8/2010. This is a vital date for the NCT in prescribing the minimum qualification for class 1 to class 5 and class 6 to class 8, wherein the TET qualification is mandatory, like the training and other academic qualifications. So, without any teachers eligibility test, without teachers eligibility pass certificate, neither appointment can be done, nor the appointment teachers can be promoted to the next level. But state government making relaxation or exemption for the eligibility by amending the cadre rule has aided in law, and by this process the discrimination has been practiced both in the case of appointment as well as in the promotion. So the relaxation and fixing the arbitrary cut-off date, that is 11/2/2011, is non-honest, and such is it is redundant. That the central government in the Ministry of HRD by their notification dated 8/4/2010 has empowered the academic authority. This is also vital. And academic authority, that is NCT, for prescribing the minimum qualification. Accordingly, the NCT has prescribed the qualification for the teacher to be appointed for the class 1 to class 8 with training and teachers eligibility test qualification. Similarly, central government by way of notification dated 17/10/2017 had allowed another 4 years to the teachers for acquiring teachers eligibility test and other training qualification by 31st, which was also given by 31st 3/2015. And those who had not acquired qualification by 31/3/2015, they were given that they were allowed for 4 years, another 4 years. That this state government of Odisha amended 1997 elementary cadre rule by way of the amendment of 2019 rule, which is contrary to Right to Free Compulsory Education Act 2009, the Right to Free Compulsory Education Rule 2010, Odisha Right to Compulsory Free Education Rule 2010, and NCT guideline, who has been conferred power by RT Act and the central government guideline, etc. The law is well settled that the state rule cannot override the central act and rule. In the instant case, the Odisha state government amendment rule 2019 is seemed to be override the central act and the rule, RT rule. So also fixing of cut-off date 11/2/2011, which is arbitrary in nature, and the proviso under rule 11(1) and 15(d)(1) being arbitrary and which are ultra virus, as such these are redundant and ought to have been declared as null and void. That some writ petitioners and appellants and have misled the Honorable Court in stating in their petition that the Right to Free Compulsory Amendment Rule 2017 has been passed in Parliament, but from the bare perusal of the bill, it has been revealed that the said bill has come for discussion and not at all finalized, approved. Similarly, there is no whisper about the promotion by way of relaxation or qualification in any act of rule. So the stand taken by the some petitioners are also redundant. That as per the settled principle of law, as decided by Honorable High Court of Madras in the case of R. Saktivel versus Tamil Nadu, and in the writ petition number 7895/2022, the TT qualification is mandatory for appointment and the promotion on the basis of Right to Free Compulsory Education Act and rule. The elementary teachers has to obtain the TT qualification being mandatory on the date of commencement of the RT Act and rule. So without TT qualification, no further promotion can be extended to any teacher. So the relaxation by way of amendment by the state government in Amendment Rule 2019 not only violates any central law, but also the discrimination in creating anomaly amongst the level of teachers. As such, the proviso under Rule 11(2) and the 15(d)(1) are required to be declared null and void. Therefore, the Odisha Elementary Education Method Recruitment Service Teachers Amendment Rule 2019, with regard to the proviso, that is Rule 15(d)(1) and Rule 11(1), are ultra virus, and the Honorable Court may struck them down, invoking the extraordinary power under Article 227 Constitution of India. So, my lord, in the overall, it is the TT, only the crux of the case, that is the TT qualification, whether mandatory or not, and whether it will be applicable in the case at the time of recruitment and in the time of promotion. Both the rule, that is the cadre rule 1997, it has been stated the teachers shall be promoted from one level to another level. In also 19 amendment rule, they have same thing. They have stated that the promotion there, the teachers shall be promoted from one level to another. So it is deemed, it is clearly admitted that the rule speaks about the promotion as well as the recruitment. So without the TET, that is the prescribed by the NCT and by virtue of the notification of the Government of India and the Act of the Right to Free Compulsory Education Act 2009 and 2010 rule and the rule state, Odisha State Rule 2010. Everybody has to qualify, that is the TET qualification. Without TET qualification, a teacher cannot be a teacher. But he may continue, but a promotion cannot be given. This is, my lord. I conclude this, my lord, hearing for your lordship's decision, my lord.
May I please your lordship? My lord, my read person 11107, my lord. My lord, in this petition, petitioner challenged the provision 15D1 of the recruitment rule. My lord, one thing I would like to draw your kind attention that in that rule, my petition, page 30, there are 7 levels in the elementary cadre rule, starting from level VA to level 1 senior. There are 7 levels, my lord. Now, at page 30, my lord, 35, the provision D2, rule 15D2, my lord. I have not challenged the D2 because it is as per the RT Act. But I would like to draw your kind attention that, my lord, D2, separate gradation list of senior teachers in level VB, my lord, of the service shall be prepared after taking into consideration the option exercised by the senior teachers, as will be notified having qualification of a bachelor degree in any discipline with secondary teachers training or certified teachers course or diploma in elementary education and pass in Odisha teachers eligibility test 1 for considering the promotion to the level 4 of the service. My lord, it is vital. Those have continuing in level 4, 5B, they have to pass level TET 1, but TET 1 to be promotion to level 4, provided that such teachers, senior teachers in the level 5B of the service exercising their option to become graduate teacher have passed Odisha eligibility test 2. That means from level 5B to any other level, if a teacher will be promoted, he or she must have to qualify in TET. Without TET, either TET 1 or TET 2, he or she cannot be promoted to any next higher level. This is the provision as prescribed by the state government in Rule 15D2, my lord. There is no such exemption for any teacher. But in D1, the state government provided exemption of a TET from level VA to level VB, my lord. Here is the crux. When teachers without TET are promoted to the level 5B and without TET they are continuing in level 5B, then how they will be promoted to next higher level, either level 4 or level 3 or any other level. Here is there is no exemption in D2, my lord. Therefore, since D1 is contravention to the RT Act and subsection 2 of the section 23 of the RT Act, therefore the petition challenged this. This is the ultra virus to be declared ultra virus. Thereafter, my lord, I am coming to page 37 and 2 clarification letter I would like to submit before your lordship. This is a clarification from NCT.
Return it.
My lord. Wherein into clarification. For promotion, teachers relevant minimum qualification as specified in the first and second schedules of are applicable for consideration from one level to next level. In para 3, since the minimum qualification laid down under RT Act 2009 by the NCT notification dated 23rd August 2010 as amended time to time, wherein passing of teacher eligibility test TET is a minimum qualification for a person to be eligible to appointed as a teacher in class 1 to 8 is an integral part of the NCT regulation 2014. Therefore, aforementioned regulations shall inherently applicable in case of promotion of teachers class 1 to 8, irrespective of their date of original appointments. Well, this is the clarification from the NCT, and the regulation of the NCT dated 12th November 2014 at para 4, it is also prescribed the same thing. This is the crux before this honorable court, that the TET having the persons having TET, teachers having TET, and teachers having non-TET. Whether the without having TET, they can be promoted to next level. This is the crux of the case, and your lordship will decide. And this is my submission before this court, honorable court, my lord. Obliged.
Yes. No, not right.
Lord, I have already given a note, and that is my lord. My lord,
Yes.
only I will say, add only one thing, that it will, the cadre rule 15 will be heavily damaged and disturbed, and that will give rise to, that is why my lord, that we have given my note.
Yes, indeed, concludes. Hearing concludes.
Lord, with your lordship's permission.
Huh?
With your lordship's permission.
So why did you say?
My lord, I will give a short reply.
You do whatever you want.
Yes, please make your submission.
Yes. My lord, I will take only short. I will take only short time. My lord, so far as the interveners are concerned, they were appointed prior to 23rd August 2010, and after enactment of the RT Act 2009, which came into force on 1/4/2010. My lord, your lordship may kindly see my bunch, which I had given earlier. My lord, may kindly see that. My lord, may kindly see the notification dated 23rd August 2010, issued by the NCT. My lord, your lordship may kindly see page 5. In exercise of powers conferred by subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009, and in pursuance of notification number such and such dated 31st March 2010, issued by the Department of School Education, Literacy, Ministry of Human Resources Development, Government of India, the National Council for Teacher Education hereby lays down the following minimum qualification for a person to be eligible for appointment as a teacher in class 1 to 8 in a school referred to in clause N of section 2 of Right of Children to Free and Compulsory Education Act 2009, with effect from the date of this notification. My lord, so far as clause 1 is concerned, it prescribes minimum qualification, that is the professional and academic qualification. So far as TET is concerned, that has been provided in clause 1B, pass in teacher eligibility test to be conducted by the appropriate government in accordance with the guidelines framed by the NCT for the purpose. My lord, thereafter, your lordship may kindly see clause 4, on which we are relying.
Well, teachers appointed before the date of this notification. My lord, got it? The following categories of teachers appointed for classes 1 to 8 prior to the date of notification did not acquire the minimum qualifications specified in para 1 above. So all these interveners and similarly situated teachers, they were appointed prior to 23rd August 2010. So they are coming under exempted category. They have fulfilled the academic and professional qualification, but so far as TET is concerned, they were exempted. Then, my lord, your lordship may kindly see clause 5. Teachers appointed after the date of notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement to initiate the process of appointment of teachers prior to the date of this notification, such appointments may be made in accordance with the NCT determination of minimum qualification for recruitment of teachers in schools, Regulations 2001, as amended from time to time. So teachers who were appointed prior to 23rd August 2010, my lord, so far as their qualification is concerned, that will be governed as per NCT Regulation 2001. In my bunch, I have given the 2001 regulation. Your lordship may kindly see in 2001 regulation, only professional and academic qualification has been prescribed. Because the concept of TT only came into force in the year 2011. So they have fulfilled those conditions. So from the very beginning, they form a separate category. They are under the exempted category. So it is not a case that they were appointed after 23rd August 2011. Thereafter, your lordship may kindly see, my lord may kindly come to page 12 of my bunch. The NCT for the first time issued a notification on 11th February 2011 because this cut-off date has nexus. Because, my lord, so far as the proviso to Rule 15 is concerned, the virus of Rule 15, the proviso to Rule 15 is under challenge, where the cut-off date has been prescribed as 11th February 2011. Those who were appointed prior to 11 February 2011, they are under exempted category. My lord, may kindly see that cut-off date has nexus with the notification of the NCT. My lord, your lordship may kindly see subject, guidelines for conducting teacher eligibility test under the Right of Children to Free and Compulsory Education Act, RT Act 2009. In accordance with the provisions of subsection 1 of section 23 of the RT Act, the National Council for Teacher Education had white notification dated 23rd August 2010 laid down the minimum qualification for a person to be eligible for appointment as a teacher in classes 1 to 8. It had been inter alia provided that one of the essential qualifications for a person to be eligible for appointment as a teacher in any of the schools referred to in clause N of section 2 of the Act, RT Act, is that he/C should pass the teacher eligibility test, which will be conducted by the appropriate government in accordance with the guidelines framed by the NCT. So this cut-off date, 11th February 2011, has nexus, which has been, my lord, which has been used in that proviso to Rule 15 of the 1997 rules. Thereafter, your lordship may kindly turn, so far as Odisha is concerned, my lord may kindly come to the page 18 of my bunch. For the first time, TET test was conducted in Odisha in 2012. My lord, so far as admittedly we are under the exempted category because we are appointed prior to 23rd August 2010. So far as regulation of 2000, so far as NCT regulation 2014 is concerned, my lord may kindly see that. That is NCT regulation 2014. My lord may kindly come to para 4. Qualification for recruitment. the qualification for recruitment of teachers in any recognized school imparting pre-primary, primary, upper primary, secondary, senior secondary or intermediate schools or colleges imparting senior secondary education shall be given in the first and second schedule annexed to these regulations. Then 4B is important. For promotion of teachers, the relevant minimum qualification as specified in the first and second schedules are applicable for consideration from one level to next level. Here, your lordship may kindly see, we are in level 3. My lord, the level has been mentioned in regulation of 2014. Level 1, preschool / nursery for children in the age group of 4 to 6 years. Then level 2, preschool / nursery followed by first 2 years in a formal school. We are coming under level 3, primary and upper primary for classes 1 to 8. The qualification prescribed is minimum qualification as laid down by National Council for Teacher Education by its notification dated 23/8/2010 as amended from time to time, issued in exercise of powers conferred under subsection 1 of section 23 of the Right of Children to Free and Compulsory Education Act 2009. So in the NCT regulation, NCT notification 23rd/8/2010, we are under exempted category because we are appointed prior to 23rd August 2010. So we are not required to pass TT examination. So far as promotion is concerned, my lord, we are not seeking for promotion from one level to another level as provided in 2014 notification or 14 regulation, because here level has been mentioned. Preschool nursery, that is one level. Preschool nursery followed by first 2 years in a formal school, that is level 2. Then level 3 is ours, primary and upper primary. And if we seek promotion to secondary, that is secondary high school for classes 9 to 10, then my lord, TT is necessary. But if we get promotion in the same level, that is from classes 1 to 8, because as per the elementary cadre rules of 1997, my lord, if your lordships will see the definition of elementary school under the RT Act, my lord may kindly see the RT Act. That is from classes 1 to 8. My lord may kindly see the definition. My lord may kindly come to the definition that Right of Children to Free and Compulsory Education Act 2009, that is available in page 169 of the education manual. My lord may kindly see 2F, definition of elementary education. Elementary education means the education from first class to 8th class. So, and so far as elementary cadre rules of 1997 is concerned, wherein the virus of rule, the proviso to virus of rule 15 has been challenged, my lord, that deals with classes 1 to 8. That is in level 3. So here, this is not a case. Here one is seeking for promotion from primary or upper primary to secondary level. Had anybody sought promotion from primary to secondary, then TT is a must, according to me, subject to a lordship's acceptance. So thereafter, my lord, my submission, my lord, exactly in similar circumstances, the Allahabad High Court has rendered a judgment. Your lordship may kindly see that. I have cited that judgment earlier. Your lordship may kindly. My lord, I have already given that judgment. Your lordship may kindly see exactly same point. My lord, I am sorry. I have earlier I have given to your lordships. I have only one copy. My lord, I am just placing it. The petitioners before this court are claiming promotion, post of assistant teacher, junior high school to headmaster, controversy is limited to interpretation of qualification prescribed by National Council for Teacher Education by way of a notification dated 23/8/2010. In that case, NCT has also filed an affidavit. Parties are in agreement that on the basis of affidavit of the state as well as National Council for Teacher Education, controversy could be diluted and clarified if this court passes an appropriate order in terms of notification and its implementation. Before passing the direction, it would be relevant to quote relevant paragraphs of affidavit filed by the NCT. That NCT, in exercise of powers under subsection 1 of section 23 of the RT Act, by notification dated 23/8/2010 and 29/7/2011, has prescribed minimum qualification for appointment as teacher for classes 1 to 8. That by these notifications, passing the teacher eligibility test conducted by the appropriate government in accordance with the guidelines framed by the NCT is one of the criteria of becoming teachers for classes 1 to 8. That the criteria for the purpose of promotion of the assistant teacher has also been prescribed by the NCT in these notifications. A copy of these notifications 23/8/2010 and 29/7/2011 is being filed herewith and marked as annexure such and such. That the NCT, in exercise of the powers conferred under clause small dd of subsection 2 of section 32 read with section 12A of the NCT Act 1993, framed the National Council for Teacher Education determination of minimum qualification for persons to be recruited as education teachers and physical education teachers in pre-primary, primary, upper primary, secondary, senior secondary or intermediate school or colleges regulation 2014. That rule 4B of the regulations 2014, which I have referred to, prescribed criteria for promotion, which is quoted below, 4B. For promotion of teachers, the relevant minimum qualification as specified in the first and second schedules are applicable for consideration from one level to the next level. That the clause 3 of first schedule of NCT regulation 2014, that minimum qualification as laid down by the NCT notification dated 23/8/2010 as time to time amended is applicable. That clause 4 of NCT regulation dated 23/8/2010 states as follows. Teachers appointed before the date of this notification, the following categories of teachers appointed for classes 1 to 8 prior to the date of this notification need not acquire the minimum qualification specified in para 1 above. A teacher appointed on or after the 3rd September 2001, that is the date on which the NCT determination of minimum qualification for recruitment of teachers in schools regulations 2001 came into force in accordance with that regulation, provided that a teacher of classes 1 to 5 possessing B.Ed qualification or a teacher possessing B.Ed special education or D.Ed special education qualification shall undergo an NCT recognized 6-month special program on elementary education. A teacher of class 1 to 5 with B.Ed qualification who has completed a 6-month special basic teacher course approved by the NCT. A teacher appointed before 3rd September 2001 in accordance with the prevalent recruitment rules. In these circumstances, this is important, it is clarified that appointees before notification dated 23/8/2010 does not mandatorily require to pass TET and their promotion be considered whether they have passed TET or not. So far as appointees subsequent to 23/8/2010 are concerned, their promotion shall be considered if they have passed TET or TET upper, as the case may be. Aforesaid exercise of promotion be concluded expeditiously, preferably within 6 months from today, if there is no legal impediment. So,
we will set the second half. This hearing will continue.
Very good.
Mr. L. Samantra, AGA, has handed over a check the name of the petitioner,
Yes, petitioner.
Saraj Chandra Senapati, worth 4,65,751, dated 18/9/2024, issued by the principal BGB Autonomous College, Bhubaneswar, comma, in full compliance of this court's order, violation of which has been alleged in the present contempt application. Stop. That's in such view of the matter, the contempt proceeding is dropped. Yes.
Maybe, pardon you.
No, Mr. Mishra.
I just wanted to assist. I had brought everything. I just missed by few seconds only.
We don't have time to decide cases. So we for one case, we are,
I am extremely sorry. I had a scope to assist.
from
your lordship.
Monday, the things will change. So it was a different matter that today.
Humbly pray, if your lordship only keep it to tomorrow, I'll just assist my lord on that point. I had made some homework.
We are not.
As your lordship.
Item 7.
Sorry, my
No
lord,
other case. We will take up no other matter.
Yes.
Item,
Sorry, sir, not today.
I'm just requesting, can it be possible, because this is an urgent matter, your lordship has posted it for today, for that interim order.
Regarding what?
Regarding the tender matter.
Then you will have to wait till this hearing of this case is concluded.
Yes, I
wait.
Yes,
I-
not now, I'll wait.
Single after it concludes, then surely single we will take up. I'll take up.
Item 7.
Yes.
Today, I'm sorry, is there a
I
chance?
argued before your lordships.
Because your lordship is sitting in a single bench afterwards,
Category of
35?
teachers who are for the interveners. They form a separate class because they were appointed prior to 23/8/2010. So therefore, in view of the notification dated 23/8/2010, more particularly clause 4, they are under exempted category. My lord, I have shown to your lordships that 23rd August 2010 NCT notification, wherein it has been clearly mentioned the teachers appointed before the date of this notification, the following category of teachers appointed for classes 1 to 8 prior to the date of notification did not acquire the minimum qualification specified in para 1 above. Para 1 includes TT. Then my second plank of argument before your lordship says, my lord, referring to 2014 notification, my lord, so far as 2014 notification is concerned, they say that for promotion of teachers, the minimum qualification as specified in the first and second schedule are applicable for consideration from one level to the next level. That has been provided in para 4, para 4B. For promotion of teachers, the relevant minimum qualification as specified in the first and second schedules are applicable for consideration from one level to the next level. Here, level, my lord, the level 1 is preschools/nursery for children in the age group of 4 to 6 years. 2, preschool/nursery, followed by first 2 years in a formal school. Then we are coming under level 3, primary and upper primary for classes 1 to 8. The minimum qualifications as laid down by the National Council for Teacher Education by its notification dated 23/8/2010 as amended from time to time, issued in the exercise of powers conferred under subsection 1 of section 23 of Right of Children to Free and Compulsory Education Act 2009. Here also they refer to 23/8/2010 notification, where we are exempted. And so far as promotion is concerned, my lord, we are within the same category, that is classes 1 to 8 in primary and upper primary schools. We are not seeking promotion to higher level, because under the RT Act, my lord, elementary school has been defined that elementary school means classes from 1 to 8. My lord, I have shown to your lordships, that is the definition clause 3F of the RT Act 2009. Elementary education means the education from class 8 to 8 class. So we are in level 3. We are not seeking promotion to level 4, that is secondary high school. So the level, the expression level which has been used in 2014 regulation, my lord, that, my lord, cannot be countenanced or negated as has been done in 1997 elementary cadre rules of 1997. So far as elementary cadre rules of 1997 is concerned, that also deals with elementary school from classes 1 to 8. For a moment, your lordship may kindly see the elementary cadre rules of 1997. It also does not refer to high school or any other college, etc. My lord, may kindly come to page 520 of that book, Education Manual. Here also elementary school has been defined. My lord, may kindly come to Rule 2G. Primary schools means the schools having classes from 1 to 5, then upper primary school 2L. Upper primary school means the school having classes up to 8. So the elementary cadre rules of 1997, because the virus of rule proviso to rule 15 has been challenged of this rule, it also deals with elementary school from classes 1 to 8, not beyond that. And so far as rule 3 is concerned, that is constitution of service, it comprises of various levels, level 5A, level 5B, level 4, level 3, level 2, level 1. It is within the elementary cadre, and there is no change of qualification. My lord, may kindly see rule 9, which deals with promotion. Your lordship may kindly see that. Sorry, rule 11, eligibility for promotion of the elementary cadre rules. Only some years have been prescribed. Eligibility 11, eligibility for promotion 1. In order to be eligible for promotion to the post belonging to level 5B of the service, the candidate must have served for a continuous period of 4 years in the posts belonging to level 5A of the service. Then your lordship may kindly see 11.2. In order to be eligible for promotion to the post of headmaster / headmistress of government primary schools in level 4 of the service, candidate must have passed high school certificate or higher secondary +2 examination, that is the original qualification, or graduation with secondary teachers training, certified teachers course / diploma in elementary education or bachelor in education, and must have served for a continuous period of 2 years in the posts belonging to level 5B of the service. Then 11.2 Roman 2. In order to be eligible for promotion to the post of graduate teachers in government upper primary schools in level 4 of the service, a candidate must have possessed a bachelor's degree in any discipline or an equivalent examination with secondary teachers training or certified teachers course, or diploma in elementary education, or a bachelor in education, and must have served a continuous period of 2 years in the post belonging to level 5B of the service. So there is no change of qualification. Then your lordship may kindly see sub-rule 3 of rule 11. In order to be eligible for promotion to the post of senior headmaster in government primary school in level 3 of the service, a candidate must have passed high school certificate or higher secondary +2 examination or bachelor's degree in any discipline with secondary teachers training or certified teachers course, or diploma in elementary education, or in bachelor in education or an equivalent examination and must have served for a continuous period of 2 years in the post of headmaster of government primary school belonging to level 4 of the service. Similarly, level 2, level 1, only some experience is necessary. So starting from level 5 pay to level 1, only some years of experience is necessary. There is no change of qualification. So far as regulation of 2014 is concerned, the level means from one level to another. And so far as primary and upper primary is concerned, that is in level 3. If one seeks promotion to higher secondary school, then, my lord, he has to pass TT examination. Then, my lord, my next submission before your lordships is, so this is relating to promotion. Nowhere it has been prescribed that for promotion, passing of TT is necessary. And my next point before your lordships is that cut-off date 11/2/2011, my lord, because the virus of the proviso to Rule 15 has been challenged, your lordship may kindly come to page 530 of that manual, elementary cadre rules. Provided that the teachers appointed against the advertisements published prior to 11/2/2011 are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teachers Eligibility Test 2. Well, this is the subject matter of challenge because they say that this is ultra-virus to RT Act. So my submission before your lordships is, my lord, this cut-off date has nexus with the object sought to be achieved, because on 11/2/2011, the NCT brought out a notification for the first time to conduct teacher eligibility test that I have given in my bunch of documents. Your lordship may kindly see that. They say that this cut-off date has no nexus. That is not correct. My lord may kindly. My lord may kindly come to page 12 of my bunch. That notification was issued by the NCT on 11th February 2011. Subject guidelines for conducting teacher eligibility test under the Right of Children to Free and Compulsory Education Act, RT Act 2009. In accordance with the provisions of subsection 1 of section 23 of the RT Act, the National Council for Teacher Education had, by notification dated 23rd August 2010, laid down the minimum qualification for a person to be eligible for appointment as a teacher in classes 1 to 8. It had been inter alia provided that one of the essential qualifications for a person to be eligible for appointment as a teacher in any of the schools referred to in clause N of section 2 of RT Act is that he should possess pass the teacher eligibility test, which will be conducted by the appropriate government in accordance with the guidelines framed by the NCT. So this cut-off date has nexus because NCT introduced the teacher eligibility test on 11th February 2011. Therefore, in the proviso to Rule 15, that date has been prescribed. And in the meantime, teachers who were appointed prior to 23/8/2010 and even prior to 11th February 2011, they have got promotion in the elementary cadre from level 5A to level 5B, level 5B to level 4. That has been admitted in the counter filed by the state. My lord may kindly, for a moment, your lordship may kindly see the counter filed by the state. And my lord, by virtue of amendment that was incorporated in 2009 and the writ application has been filed in 2023 after 4 years. My lord may kindly see the additional affidavit filed by the opposite party number 2 in WPC number 17780 of 2023. In my bunch of documents I have given. Earlier I had given that. My lord may kindly see paragraph, that is the state's additional affidavit. My lord may kindly come to paragraph 10. That the petitioners in the present writ application basically seek to challenge the relaxation granted to the teachers appointed prior to 2011 from acquiring the OTT qualification on the ground that same runs contrary to the Amendment Act 2017. In this context, it is humbly submitted that during the year 2020-21, 21-22, 22-23, and 23-24, 68,800 large number of teachers having no OTT qualification, those who were appointed prior to that cut-off date 11/2/2011, have been promoted to various levels in the elementary cadre in view of the relaxation granted as per the amendment rules 2019. It is further humbly submitted that after the guidelines for OTT was framed by the state by resolution dated 4/6/2012, not a OTT was introduced in 2012, although the central notification was made on 11/2/2011. But admittedly, these teachers were appointed prior to 23/8/2010. They are under exempted category. That is my submission. Then my next point before your lordships is, my lord, on last occasion, my lord, I produced that legislative note or the object of the bill. My lord may kindly see that. I have given that by way of an affidavit. Yes, affidavit again. My lord may kindly see my affidavit. I have annexed that note. In my bunch also I have given the highlights of the bill. The second paragraph, page 5. The right of children to free and compulsory Education Act, RT Act 2009 became effective with effect from 1st April 2010. It envisages free and compulsory elementary education to every child in the age group of 6 to 14 years. The proviso to section 23(2) of the Act specifies that all teachers at elementary level who at the commencement of this Act did not possess the minimum qualification as laid down in subsection 1 of said section under the RT Act need to acquire these qualifications within a period of 5 years from the date of commencement of the Act, that is 31st March 2015. After completion of the said period, the state government have not been able to continue the training process for in-service untrained teachers, and the state government have requested for extension of the period of training untrained teachers so as to enable them to initiate and complete the said training process. Then my lord referred to that note appended to that bill. Any person possessing such minimum qualification as laid down by an academic authority, here academic authority means NCT, authorized by the central government by notification, shall be eligible for appointment as a teacher. So that is only for appointment of a teacher and not for promotion. My lord, that question, my lord, my lord pointed out that, so that is only for the purpose of appointment. And here, since these teachers were appointed prior to 23/8/2010, so they are under exempted category. So they did not require to acquire OTT qualification because for promotion that is not necessary. And so far as Allahabad judgment is concerned, that is in the same line, interpreting 2010 notification and 2014 regulation. Well, that judgment was given that if a person has been appointed prior to 23/8/2010, he did not require to pass OTT examination and he can be promoted to higher level. And so far as Amendment Act 2017 is concerned, my lord has seen that. So this is my argument. Your Lordship, before I place my facts, I must have to bring to my Lordship notice that we are all appointees of 2000 year, 2008 as level 5 teachers. And admittedly, we are all governed under the 1997 rules, my lord. At this juncture, I would like to draw my lord's attention that what is the prayer made by the petitioner. Clause 3. Issue rule listed calling upon the opposite parties, particularly opposite party number 1, asking so cause as to why the impugned portion of absolute exemption given to the teachers appointed prior to 11/2/2011 under proviso to Rule 11(1)(d)(2) and exemption, etc. My lord, so far these amendments were incorporated in the statute book in the year 2019. Therefore, you will also kind of a look that though other amendments were made, they are only aggrieved because of the proviso that is prescribed under, you will also get it at page 530. Provided that the teachers appointed against the advertisement published prior to 11/2/2011 are exempted from passing Odisha Teachers Eligibility Test 1 and Odisha Teachers Eligibility Test 2. Therefore, my lord, there is a nexus of 11/2/2011 is concerned why it was incorporated to the statute. In order to appreciate me, my lord, may I draw my lord's attention that right to information that Act came in the year 2009. 2009 came into the year 2010. Just a minute. Therefore, my lord, according to this provision, my lord, can have a look to the qualification prescribed. Though my lord has explained it, I do not want to take more time, but recapitulate myself, my lord. Rule 23, qualification prescribed where the state government where the state doesn't have adequate institution, etc., my lord, then the provision that is prescribed any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. Rule 23(1). My lord, by that time, after this rule came into force in the year 2010, your lordship can have a look to the page 74. 72. I'm sorry, 72. I'm sorry, 72, Annex 6 by A in my affidavit. The state government, my lord, by way of a gazette, in exercise of the powers conferred by section 2 of the Right to Children Act, hereby authorize the National Council of Teachers Education to be the academic authority for this purpose of prescribing the minimum qualification. Therefore, my lord, this has come on 31st March 2010. After this notification was issued on 23rd of August 2010, the central government, as for this notification, National Council of Teachers Education, your lordship will get it at page 77, prescribed the minimum qualification. At one minimum qualification, class 1 to V, page 77, my lord, I'm placing. Senior secondary teacher, etc., senior secondary teacher. We are concerned so far as clause 4 of the said notification. gazette notification. Teachers appointed before the date of this notification on 23rd August 2010, the following categories of teachers appointed for classes 1 to 8 prior to date of the notification need not acquire the minimum qualifications specified in para 1 above. Then you also can thereafter the teachers appointed after clause 5. The teacher appointed after the date of this notification in certain cases. Therefore, my cut-off date is 23rd April 2010. After 23rd April 2010, where an appropriate government or local authority or a school has issued an advertisement to initiate a process of appointment of teachers prior to the date of the notification, such appointment may be made in accordance with NCT determination of minimum qualification for recruitment of teachers rule regulation 2001 as amended from time to time. At this regard, my lord can have to look to at page 68 of this said affidavit. At page 68, unnecessary 5/8. This is National Council of Teachers Education issued the notification on 3rd September 2001 where it has prescribed the educational qualification. The educational qualification, your lordship will kindly get it at page 69. So far the primary school is concerned, training or duration of not less than 2 years, bachelor's elementary education or graduate, etc. or seniors, all these qualifications, my lord, we are having, those were appointed by that time. Now, July 2011, NCT, my lord, has issued a notification. Your lordship can have come to page 81. For para 5 of the page 81, my lord. For para 5 of the principal notification, the following shall be substituted, namely 5A. Teachers appointed after the date of this notification in certain cases, where an appropriate government or local authority or a school has issued an advertisement of initiate the process of, this is just reiteration of what has been issued earlier, my lord. Now, my lord, question comes, when we are appointed, and at that time, my lord, there was no question of any other qualification except the qualification prescribed by the state government, which was concurred by the, under the rules and statutes. Now the question is, my lord, why they have incorporated that date, my lord, in that amendment? Rule. That is 11th of February 2011 is the cut-off date under the rules, my lord. You'll also get it at page 82. Annex 9/A. Because for the first time, this is issued by the National Council for Teachers Education, NCT, subject guideline for conducting teachers eligibility test, TET, under the right of children of free and compulsory education Act 2009. In accordance with the provisions of section 1 of section 23 of the RT Act, the National Council of Teacher Education, NCT, by notification dated 23rd August 2010, laid down the minimum qualification for a person to be eligible for appointment as a teacher in class 1 to 8. He had been inter alia provided that one of the essential qualification for a person to be eligible for appointment as a teacher in any of the schools referred to in clause N of the section 2 of the RT Act
is that she or she should pass the teacher's eligibility test TET, which will be conducted by the appropriate government in accordance with the guidelines of the NCTC. In this regard, please enclose the guideline for conducting the teacher's eligibility test for necessary action at your level. For the first time, 11th of February 2021, the TET exam was conducted by under the guidance of the NCT. Now, my lord, question is, that is why, under the amendment provision, this date of 11th of February 2011 has been mentioned. Because prior to that, the TET was not available. We are all appointees prior to this, and we are all covered under the provisions of that act. Therefore, my lord, rightly, the state government, but in furtherance to the regulations or the instructions issued by the Council of Teachers Education, has prescribed and provided that provision. Therefore, no wrong has been committed by the state, and there cannot be any ultra virus to that provision.
Right, please, ma'am. Prayer, my lords, essentially is a challenge to the vires of the rule. An intervention, my lords, in WPC number 10430 of 2024, where, my lords, they have prayed. Because I will not add anything which has been my lord, already my lords, placed before your lordship by my learned seniors. The issue rule is calling upon the opposite parties, particularly opposite party number 1, to asking to show cause as to why the impugned portion of the absolute exemption given to teachers appointed prior to 11/2/2011 under proviso to Rule 15(1)(d)(2) and exemption under Rule 6 and 11, and consequential letters and actions of the government opposite parties shall not be declared illegal, arbitrary, discriminatory, and ultra vires to the amended section 23 of the RCFC Act 2009 and Rule 17 of the RCFC Act 2010, Rules 2010 read with NCT notification dated 23/8/2010 and NCT regulation dated 2014. Regulation 2014, my lord. Now, this is the proviso under Annexure Rule 15 that your lordship finds at page 66 of the state government, my lord's regulation, which is they have annexed to the my lord's writ petition at Annexure 6, where, my lords, at page 59 it starts. In exercise of the powers conferred by the proviso to Article 309 of the Constitution of India, and the Governor of Orissa hereby makes the following rules further to amend the Orissa elementary education method of recruitment and conditions of service of teachers and officers rules 1997. Then, my lords, page 66, provided that the teachers appointed against the advertisements published prior to 11/2/2011 are exempted from passing Orissa Teachers Eligibility Test 1 and Orissa Eligibility Test 2. Now, my lords, necessarily, my lords, this, as per the petitioners, in order for the petitioners to succeed, has to fall foul somewhere of, my lords, section 23 of the RCFC Act 2009
or the notification 23/8 dated, central government notification dated 23/8/2010 or NCT regulation 2014. In the same manner, the state government act would only be ultra vires if it provides for something not already provided, or if it gives an exemption which is not granted under the central act manner. To that extent, I draw your lordship's attention to as has already been drawn to that notification dated 23rd August 2010 4. Teachers appointed before the date of this notification. C. A teacher appointed before the 3rd of September 2001 in accordance with the prevalent recruitment rules. Now, we are all appointed prior to that date, cutoff date, as prescribed, 11/2/2011 through open advertisement. So we are all regular appointees whose qualifications as under the extant rules have been saved, virtually saved by granting this exemption. So we are not disqualified under the new rules. Now this saves us and also our right to promotion. That your lordship finds at page 67. 4. The notification of the central government dated 2014, 12th November 2014, which deals with qualifications for recruitment, rule 4(2)(b). For promotion of teachers, the relevant minimum qualifications as prescribed in the first and second schedule are applicable for consideration from one level to the next level. Now, levels having been provided in the left-hand side of the table, left-hand corner of the table, we are all under the third serial primary and upper primary for classes 1 to 8. So unless it's a question of jumping from one level to the other, we are not, we don't fall foul of any rules, and the state government's regulations are not ultra vires the central act. That is the submission.
Meeting concludes.
My lord, so far as writ appeals are concerned, it will be dependent on your lordship's judgment in the.
I will submit a short note with citations.
I will also. I have small prayer to make, your lordship. Your lordship has heard the virus of rule 15, but in the fourth sub-item, I have challenged the virus of rule 11, your lordship. It has not been heard. Can I argue, your lordship?
Yes.
My lords. Lordship, kindly come to page 34. In the WPC number 358/2023. For the first time, for controlling the cadre of the elementary education 1997 rule came into force. Is the lordship with me? At page number 35, your lordship kindly see the primaries, the cadre of the elementary education will divide into two categories. One is primary schools and upper primary schools. The primary school starts from class 1 to 5, and so far as the upper primary school are concerned, they are up to 7. At rule 3, should I?
Please continue.
My lords. The rule 3 specifies the constitution of service. The service shall comprise of the following levels, namely the Odisha Elementary Education Service level 5 up to level 1. Thereafter, your lordship, at page 40, it prescribes the eligibility for promotion. Rule 11, page number 40, your lordship. Eligibility for promotion. In order to be eligible for promotion to the post belonging to level 4 of the service, a candidate must have served for a continuous period of 8 years in the post belonging to level 5 of the service, and accordingly up to level 1, it has been prescribed how it will the promotion will be given effect to. Now, subsequently, the 1997 rule came into an amendment in 2014. It is at page number 47, Your Lordship. At page 47 on 1/7/2014, the amendment took place. And what was amended, Your Lordship? That's at page number 48. Now, in upper primary school, in 1987 rules, it was up to class 7. But now it has been extended to class 8. And after the level 1 post of elementary education service, a new level was added, that is level 1 senior. And at page 52, for the very first time, the concept of that upper primary school and the lower primary school came into force. Now, if His Lordship will kindly see Rule 11 at page number 52 of the amended rules, it specifies in the 11(1) proviso, 50% of the vacancy shall be filled up by the candidates having passed high school certificate or higher secondary 10+2 examination with secondary teachers training certified teachers course from any recognized board or university or equivalent thereof. And in sub-rule 2, it has been prescribed that 50% of the vacancies shall be filled up by the candidates possessing a bachelor degree. So there are two categories. One who is having 10+2 with CT qualification, and another one that is bachelor degree in the relevant discipline. At rule number 2, in order to be eligible for promotion to level 3 of the service, a candidate must have possessed a bachelor degree in any discipline with a bachelor degree in education or an equivalent examination. So basically, which it states, if anybody is having a BA degree or equivalent degree, he is eligible and entitled for promotion to the next higher post. It is level 3 and level 2 as well. Now, what is the grievance of the present petitioner is that it came into force in 2019. It is at page number 67. Page number 67, the 1997 rules further came into amendment. And in the amendment, at rule number 3, Constitution of Service, they have incorporated two new rules, new cadres. So it is 5A and 5B. The initial appointment of a teacher will be under 5A, as the assistant teacher. And after that, they will be promoted to next level, that is 5B, to the senior teachers. It is prescribed there, Your Lordship. At the next page, 69. The 1A has been prescribed that the Odisha Elementary Education Service level 5B shall consist of the post of senior teachers of government primary schools and senior teachers of government upper primary schools. Now, I have shown your Lordship that in 2014 rules, now under 2014 rules, even though a person was appointed as a teacher and is having 10+2 with CT certification, but if he possesses BA degree, he can also be eligible for promotion. But in the new rules, 2019 rules, that same avenue of promotion has been curtailed. And how has it been curtailed? I will demonstrate that, Your Lordship. At page 73, the 1997 rules has gone into amendment 2019.
Please continue. We are not stopping.
My lords. I just think that I'm
No,
making
please
sense
continue.
or not. That
Please
is-
continue. Whatever you have to say, you say.
My lords. Under Rule 11 at page number 73, this is the new amended rule. In order to be eligible for promotion to the post belonging to level 5B of the service, the candidate must have served for a continuous period of 4 years in the post belonging to level 5A of the service, provided that 50% of the vacancy shall be filled up by the candidates having passed high school certificate or higher secondary 10+2 examination or graduation with secondary teacher training, certified teachers course, diploma in elementary education from any recognized board or university or equivalent thereof, and have passed Odisha Teachers Eligibility Test 1 for candidates engaged as Siksha Sahayak or junior teacher contractual against the advertisement published after 2011. 2. 50% of the vacancy shall be filled up by the candidates possessing a bachelor degree. The bifurcation is there, Your Lordship. One is that 10+2 with CT or bachelor degree. You are not agreed with that. Your Lordship, the next is clause 2. in order to be eligible for promotion to the post of headmaster, headmistress of the government primary schools. Let's kindly mark that primary schools in level 4 of the service, candidate must have passed high school certificate or higher secondary +2 examination or graduation with secondary teachers training, certified teachers course, diploma in elementary education or bachelor in education, and must have served for a continuous period of 2 years in the post belonging to level 5B of the service. My lords. Now in 3, in order to be eligible for promotion to the post of graduate teachers in government upper primary schools in level 4 of the service, a candidate must have possessed a bachelor degree in any discipline or an equivalent examination with secondary teachers training or certified teachers course, a diploma in elementary education or a bachelor in education, and must have served for a continuous period of 2 years in the post belonging to level 5B of the service. Provided that in case of a non-availability of adequate number of persons for promotion to level 4 of the service, 6 years of service in level 5A and 5B shall be taken together for consideration of promotion, but must have rendered at least 1 year of service in level 5B. Now the real dispute came into picture at Rule 3. In order to be eligible for promotion to the post of senior headmaster in government primary school in level 3 of the service, a candidate must have passed high school certificate or higher secondary +2 examination or bachelor degree in any discipline with secondary teachers training or certified teachers course or diploma in elementary education or bachelor in education or an equivalent examination, and must have served for a continuous period of 2 years in the post of headmaster of government primary school belonging to level 4 of the service. And 2 says, in order to be eligible for promotion to the post of headmaster in government upper primary school, this is relevant to your lordship, in level 3 of the service, a candidate must have obtained a bachelor degree in any discipline with secondary teachers training or certified teachers course or diploma in elementary education or bachelor in education or any equivalent examination, and must have served for a continuous period of 2 years in the post of graduate teacher belonging to level 4 of the service. 4. In order to be eligible for promotion to the post of assistant block education officer in level 2 of the service, a candidate must have possessed a bachelor degree in any discipline or an equivalent examination with secondary teachers training or certified teachers course or diploma in elementary education or a bachelor in education or any equivalent examination, and must have served for a continuous period of 2 years in the post of headmaster of government upper primary school. So far as the present petitioners are concerned, they are working as headmaster in the primary school, and the next promotion avenue is senior headmaster. And after that, there is no promotion avenue for that principal, for the headmaster's lordship. But so far as the graduate teachers are concerned, who have already been appointed with the same qualification and the same advertisement, now they can be promoted up to level 1. What is that level 1? Level 1 is block education officer. So far as the petitioners are concerned, I have already shown you lordship the previous rules. In previous rules, there was no such discrimination. In the previous rules, they have stated that if you possess a bachelor degree, you are eligible for promotion up to level 1. But so as this new rule came into picture, this new rule curtails the very right of promotion of the petitioners who have been appointed in the primary school prior to the rule came into force. And now they have been promoted to the post of headmaster in the primary school, which is up to class 1 to 5. And so far as the other teachers are concerned, who were appointed as graduate teachers and possess the bachelor degree, now they have been promoted. They can be promoted to level 1 block education officer. And so far as my rights are concerned for promotion, I am curtailed at level 3. From level 3, I will not be promoted to any next higher post. Now, in the counter affidavit filed by the state, they have absolutely given no reason as to why such a discrimination and a bifurcation has been done. Your lordship, pages the counter affidavit filed by the state, your lordship.
Let's say whatever you want to say. Yeah, you're seeking permission. You have permission to make your submissions to 430 or even beyond that.
No, your lordship, I have
No,
to.
you point out and continue.
My lords. In the counter affidavit, the state has not given any reason as to why such an amendment was required. At page number 6 of the counter affidavit, paragraph number 15. they stated that is somebody submitted that petitioners in the present writ application have matriculation and +2 qualification, have expertise in teaching primary classes only. It's from class 1 to 5. As such, they are being provided avenues and opportunities in the aspect only. But to hold the post of ABEO, that is Assistant Block Education Officer in level 2 of service, one have to possess expertise in monitoring school administration, management, support to teachers, and well versed about rules and regulations surrounding the department. For the petitioner concerned, they are also being appointed as headmasters, Your Lordship. The Right to Education Act 2009 doesn't prescribe any such bifurcation or discrimination with regard to promotion of the petitioners or any other administrative persons who are appointed as teachers in primary school or upper primary school. That is their only ground of the counter affidavit. Apart from that, they have not taken any other stand. Can I again repeat my submission here? 2014 rules, which was amended, there was no such discrimination with regard to promotion. If anybody possesses a bachelor degree, he can be promoted to the up to level 1 as a block education officer. For the first time in 2019 rules, they have incorporated such a rule where they have made it two discrimination. One being that you go to level 5B. After going to 5B, you can be promoted up to senior headmaster. That is a level 3 post. And so far as the graduate teachers are concerned, they possess a bachelor degree, they will promote it to the level 1, that is BEO. But so far as the petitioner are concerned, they also have the same qualification. That is that under Annexure 7 series, Your Lordship, I have enclosed my B.Ed certificates and CT certificates.
My lord, friend, he has pointed out two things. One is the virus challenge to the virus under Rule 14 revised.
Note of submission.
You have permission to repeat your arguments 20 times. You can make your submissions even beyond 4:30 if you want. We will be concluding the hearing of the.
My lords, I am not against that, but I'm just.
You can argue what you have argued already. You can repeat that
Yes,
4 times, 5 times, whatever. We have not able to understand. We have not been able to understand one thing, that you are challenging the rule ultra-virus what?
Of Rule 11 of the 2019 amendment rules, Your Lordship.
You are challenging the rule something ultra-virus what?
Rule 11, Your Lordship. But the
Rule 11 is ultra-virus what? Universe.
Oh, Article 16 and 14A.
Yes, please continue.
Can I just show that rule, Your Lordship?
Whatever you want to show.
I've just made my submissions, Your Lordship. Rules with your rules. My basic submission is with regard to the discrimination. Why I'm saying so, the cadre rule formed in 1997. In 1997, if anybody who's possessed this BA and +2 certification, he is eligible for appointment. In the promotion, there was no curtailment that you have to possess a bachelor degree or not. And the senior teachers, they are promoted also. In 2014, they have made a distinction that you have to possess a bachelor's degree, which the benefit also possess. Now in 2019, can I just interest Lordship to page 73, just for a moment. Just for a moment, page 73.
Please read it.
Why don't you point out, Mr. Biswal?
It's
We are
70.
hearing you. You point out, we are hearing you.
I beg apology, Lordship, I will.
Please read it.
Page 73, Rule 11. That's the eligibility for promotion, which I'm challenging right now. On the ground that prior to 2019, I've already. Okay, sir, kindly allow me. And Rule 11, 2019 amendment, they have curtailed the present petitioner's promotion up to level 3. And how they have curtailed is at rule number 4. Rule number 4 states, in order to be eligible for promotion to the post of Assistant Block Education Officer in level 2 of the service, a candidate must have possessed a bachelor degree in any discipline or an equivalent examination, a secondary teachers training or certified teachers course or diploma in elementary education, or a bachelor in education or any equivalent examination, and must have served for a continuous period of 2 years in the post of headmaster of government upper primary school. So from level 3 to level 2, you have to be a teacher of a government upper primary school. So far the primary schools are concerned, the present petitioner belong, and who are working as headmaster in level 1 to 5, there is a promotion avenue for them. Prior to 2019, rule came into force in 2014. If I will to 2014 also, they have made such a distinction, but they have made that you have to possess a bachelor degree. If you possess the bachelor degree, you are eligible for promotion, irrespective of the fact that you are from a primary school or upper primary school. Now, for the first time in 2019, they have built up such a criteria, and the petitioner didn't have also a chance to object to such a rule, Your Lordship, because they are already working as a primary school. And these petitioners, they also possess a bachelor degree with CT certification. So in the midst of my appointment, I cannot change my position from a primary school to upper primary school. That is my full submission, Your Lordship. I will.
My learned friend has challenged eligibility for promotion as per Rule 11, my lord. And 11.4, he has challenged it on the, we have stated that the educational qualification they possess is lower than the education who will be promoted to this upper primary, government upper primary school. So therefore, that is the reason they will be adequately placed for to look after the job profile of the higher promotion. That is why this amendment has come to have been made, my lord. That we have said in our counter, my lord, and ultimately, my lord, it will be decided after the this virus matter is ultimately, because those dates were reflected in proviso 1 italic 1 and also 1 italic 2. The same date was incorporated there, my lord.
Just to counter my argument to my learned senior, my learned senior had not seen ISHA 7 series. On ISHA 7 series, I also possess a bachelor degree. Just because I have opted to be a teacher in a primary school, that is not a ground for curtailment of my promotion. And ISHA 7 series, I also have B.Ed certification with CT, which is required for promotion to level 2. I will conclude my argument, Sir. And I can I, with Lordship permission, I will submit a note of submission so that Your Lordship can do it.
Mr. K.B. Panda is here. Mr. Panda was mentioning in the first hour, thereafter somebody else. Mr. Mahanti was saying. Mr. Mahanti, please.
Our matter, can it be taken up tomorrow or Monday? Monday. Yes, because that is an interim matter where Your Lordship has posted it for today. That tender matter with regard to that 108 ambulances, ambulance services.
They were asked to file a counter.
Yes, they have filed. They have filed.
My learned friend has filed a petition for amendment of the writ application.
Yes, because Milord, after Your Lordship has passed the order that saying that today will be passed the interim order, they have on that very date they have executed. After that, they have executed this executed the agreement. Therefore, in order to bring that, so we have filed an application for amendment. So that is what they have given that is L1 becomes a certified that bidder. And also for this, this is what we brought in the record.
Have you filed the amendment?
Yes, yes, we have filed.
So we'll need to,
Yes,
Milord,
yes.
we'll need to file a counter to the amended petition, Milord.
That can be allowed if your lordship say.
Yes.
Milord, we'll need to file a counter to the amended petition. I-
To the amendment. Once that is allowed, you will be.
That's right. But to the amended petition, Milord, your lordship, of course, your lordships in your wisdom, Milord, kindly allow it. There's no difficulty. But Milord, we will then be given a chance, kindly, Milord, to file a reply to that amended petition, Milord.
Is this consolidated writ they will file?
Milord. Yes.
So Monday, would your lordship be pleased to have it at 2 p.m., Milord? I'm sorry, I couldn't hear your lordship. I'm so sorry, Milord.
We can take up the matter at in the first hour.
Very well. As your lordship like.
Just a minute. 2 p.m.
As your lordship.
Just a minute. So we will take up the matter at 2 p.m.
I'm so grateful, Lord. So grateful to your lordship.
All right, 2 p.m. because there is no matter fixed at 2 p.m. tomorrow, on Monday. We will take up.
Grateful, Lord. Deeply grateful.
Amendment we are allowing.
Yes, Lord. And we'll file a reply by Monday, Lord.
Yes. Yes.
The lordship's permission, item 20. The lordship's, this is an admission matter. Admission to my college has been stopped by the Skill Development and Technical Education Department. That's if your lordship will kindly consider taking up tomorrow. Subject to your lordship's convenience. It was listed yesterday.
Which institution is this?
This is Millard's is offering education in post diploma in industrial safety, and there your lordships.
So who has stopped?
The Skill Development and Technical Education Department. Why, Millard? Because this is Millard's second round of litigation. Your lordship passed a detailed judgment, page 23-page detailed judgment. Your lordship's own judgment, deprecating their practice of not allowing the admission without assigning any reasons whatsoever. After your lordship,
that was for a particular academic session.
Yes, Millard. And thereafter they have repeated the same thing once again. That is why I am before you.
When did you file your writ petition?
Millard, I filed Millard on 27/8. I have filed.
So what is the last date for admission?
Millard's last date, Millard, is it was yesterday, Millard 17. But Millard, there have been instances where your lordships have there are some judgments where subsequently.
But a copy of the writ petition has been served on you.
Yes, yes, Millard. It's been.
Have you? Can you file your affidavit?
I'll try your lordship by tomorrow.
By Monday.
Monday I'll try.
Monday.
My pleasure. I'm so grateful.
Discuss matter on taken up the first 5 cases. So it is expected that the meanwhile counter affidavit is filed on behalf of the Education Department.
The Skill Development and Technical Education.
Skill Development Services Department. On behalf of the concerned opposite parties by Monday, considering the urgency of the matter, which pertains to admission. Academic course or which course?
Yes, it is post diploma in industrial safety.
Post diploma in industrial safety course.
Deeply placed.
Oh.
Pardon. I mean, pardon, my lord, your lordship, last revision I filed a memo regarding that content, my lord, your lordship be taken up Friday, my lord, is a fresh content, my lord.
See, according to me, contempt matters are not urgent.
Well, this is urgent, my lord.
See, contempt matters are not urgent because we pass orders either punishing or exonerating a person. So
That does not benefit.
But this case, your lordship, I am the option purchaser. I'm investing 35 lakhs. They have not accepting the tax, your lordship. So my vehicle is standstill, my lord, due to acceptance of tax, my lord. I've invested the 35 lakh to purchase that vehicle, my lord. The authority, my lord, sitting over the order.
Which authority?
That RTO Chandigarh.
RTO?
Chandigarh.
Give
This
yours. There is an order.
The order is there. Your lordship,
Who is for the estate?
My lord.
Someone, you are for the estate. State of, give your slip to him.
My lord, I'll give.
Give the slip to him. And make a mention on next Wednesday.
Friday, yes.
Next Wednesday, you make a mention.
My lord.
My lord,
Please see why orders are not being complied with.
Yes.
my lord, there is another.
See, I must caution, Mr. Counsel. Yes, you can tell your officials that so far I have been very lenient in contempt matters. And I don't know which case will take a very serious turn, at what level. All right, so it may appear to be very simple, like RTO not complying with the order. But even the top of the department, top official of the department may be taken to task. So
the orders have to be complied.
Let the departments have some machinery, some system to ensure that the orders are complied with. So far, I have been pressing for implementation of the orders, not for initiation of proceedings. So,
Yes, ma'am.
My lord, there is another urgency because the petitioner is.
Contempt.
Yes, yes, my
Contempt,
lord.
what do you want? Contempt.
But the petitioner is a widow old lady, 60 years above,
All right.
and
Give
deprived
us-
of her pensional benefits.
Slip. Give him.
Thank you.
Pensionary benefits, Mr.
Yes, ma'am.
Give him.
Thank you, thank you.
And
ma'am.
make a mention on Wednesday,
Thank you.
next Wednesday.
Thank you, ma'am.
And you just remind me that you had made a mention.
Arbitration.
It is the matter. Let's set this item number 1.
Lordship, that item now it's a time extension matter. I'll withdraw your lordship. I'll file it with the.
Oh. It's a liberty to make an application before appropriate forum for extension of mandate of the arbitrator. Extension, you want extension or substitution?
Extension, your lordship.
Mandate of the arbitrator. Yes.
Lordship. I beg your pardon, your lordship. Your lordship has fixed the time, your lordship.
No.
Lordship.
Item number 2.
May I please your lordship?
On appears.
My lord, I am appearing on behalf of the conducting counsel. My lord, the conducting counsel family member has expired, so it's a 1 week time for.
For what? All right. Yes. Next.
Item number 3. Well, it's a fresh matter, my lord. And similar matters, your lordship has already issued notice, my lord. It's a part of batch of the matter, my lord. 29 was listed, 1 was left out.
Issue notice.
Grateful, ma'am.
Why should we tag with this?
My lord, they are all single matters, my lord. They were listed last week, my lord. This is listed today. There's only one matter.
What is this matter on?
Same petitioner and same.
2024 along with the ARBP number 49 of 2020.
I'll also take notice on this, man. I'll also take notice of this. Grateful. Item number 4.
Lordship, item 4. Lordship, we have filed this application under section 11+5 of the Arbitration and Conciliation Act.
First time.
Your Lordship.
So let notice go.
Your Lordship.
Let notice go.
Your Lordship.
Item number 5. Item 5.
May I please, Your Lordship?
Someone is there from your side. क्या फाइल क्या है? Where does he mention that? The petitioner in person is not present. The defect has been removed. After 17/11/2020, the defects have been removed. Stop. This application has been filed for restoration of which case? ARBP number 79 of 2022, which stood disposed of or stood dismissed for default by an order dated 16/12/2022. Stop next. Considering the nature of explanation put forth in the application seeking application for restoration of so and so, this application is allowed. Stop. Limitation, if any, stands condoned. Stop. The let ARBP number so and so be restored to its original file. Let this order be communicated to the petitioner. Let ARBP number 79 of 2022 be listed under appropriate heading on 3 weeks. 3 weeks. After a copy of this order be communicated to the petitioner through the registry. Yes.
For admission item 6.
May I please, Lordship? Notice has already been issued, minutes. I have discussed with my learned friend, proposing the name of Justice Pramod Patnaik, appointment of these 3 cases already taken.
Pramod Patnaik. Yes, with the consent.
6, 7. Your Lordship, may I kindly record the name of Mr. Shaunak Mishra for the Odisha State Disaster Management Authority?
He is not here.
Really?
And we don't know where is he. That is the whole problem.
He is the principal employer. They are the principal employer. They are the main contestant. Anyway,
Oh, then he should be here. Otherwise, how can
His name is not there in the cause list today. I spoke to him.
I've taken his consent.
that is not proper. He should have joined online.
It will come on next Wednesday.
But state is also a party. So why not?
State cannot, who is your agreement was with whom?
The agreement
The
is with
principal employer is the OSDMA, Orissa State Government, but agreement with the state on behalf of OSDMA.
The notice has been issued to state.
State also.
The arbitration notice.
Still, but where is the agreement?
Agreement is page
Page 12.
my lord,
This is
specific
item number 6.
page 15. It is clear, my lords. Page 15 of the brief, my lords. Second point, my lords. The Chief Engineer Rural Works 2, Odisha, Bhubaneswar, under Rural Development Department on behalf of
Just a
Odisha.
minute, which paragraph you are reading? 2.
On 2, my lords, paragraph 2, page 15, my lords, of my brief, my lords. 11.6. Paragraph 2, the Chief Engineer Rural Works Department and Rural Development Department on behalf of Orissa Disaster Management Authority now invites bids for the construction of works are detailed in the table below. So both but the payment authority and the principal employer is the OSDMA, Orissa State
No,
Disaster.
but where is the agreement?
Agreement, as part of the agreement, my lords.
Page 12 and 13, man. Starts at page 12.
12. Starts at page 12. This is part of the
Sorry,
agreement.
that is not an agreement.
Agreement 13, my lords. 13.
13 is the agreement. Where is the arbitration clause?
Arbitration 25.3, my lords. At page 48, 25.3, the arbitration shall be conducted in accordance with the arbitration procedure stated in the special cause of contract. That is at page 59, special contract GCC clause 7, my lords.
48.
Page 59, my lords, that's the special cause contract 25, the last paragraph 4.
Page 48.
59. 59. 59, the last portion, 25.3A.
Just a minute. Page for 50.
59, malus.
Yes.
59. In case of difference between the employer and
Yes.
malus. Malus got him. Statement 3, that it continues for the next page, that is 60 minus may omit. Page 61 F, where the value of the contract is 50 millions and below, the dispute or difference arrangement shall be referred to the sole arbitrator. That is the special contract.
We're reading 25 point?
25.3 at page 59.
Yes.
Malas. In case of dispute of difference arising between the employer and a domestic contractor, any matter arising out of a connected to this agreement, such disputes in difference shall be settled in accordance with the Arbitration and Conciliation Act 1996. The arbitral tribunal shall consist of 3 arbitrators that are not coming. Then let's come to F. A, B, C, D, F. That is A. I'm coming under F. That is page 61, my lords, where the value of the contract is rupees 50 millions and below. The disputes or differences arising shall be referred to the sole arbitrator. The sole arbitrator should be appointed by agreement between the parties, failing such agreement by the appointing authority in the president of institution. So after failing with mutual consent, the arbitrator is appointed, then recalled. They again recalled, my lords. For that I have approached against my lords.
Who is the signatory?
Executive engineer, my lords. Signatory is executive engineer.
Executive engineer?
My lords. He is a party, my lords.
Yes, the agreement was between the petitioner and him.
Yes, ma'am.
Executive engineer, you are representing executive engineer.
Yes,
my
ma'am.
lords.
The petitioner has invoked clause 25.3
point F of the which is the arbitration agreement. Arbitration clause of the, whether I have referred to correct clause or not?
Malus, 25(3)(f).
No,
Malus, absolutely right. Malus.
No, not 25(3). It cannot be 25(3).
Clause 4 of 25 of the special clause at page 59, clause 4, the procedure of arbitration will be as follows. Page 59.
What? 25(3)(a).
25(3)(a) and F at page 61. F.
25(3)(a) of general GCC.
GCC.
Of general contract. 25(3)(a) of the general clauses of contract, which is the arbitration agreement. Arbitration clause for appointment of arbitrator under section 11 bracketed sole arbitrator under section 11 bracketed 6 of the 25.3 bracketed F of the consent of the party. Yes.
Deeply obliged, Malus.
Item number 7.
I have filed the translated copy of the Odia annexure. That is kindly see page 24. That annexure 1, page 24.
For the other side.
Other side not appeared, even if notice has been duly served. Your Lordship's order dated 19/7/2024 may kindly see that notice validly served upon the opposite party. No one has entered appearance on behalf of the opposite party. Let this matter 2/8/2024 outing appearance on behalf of the opposite party, but none appears till today.
What is the amount?
Very small amount. That is a piece of land has been sold without knowledge of this petitioner. With a development agreement for construction of building, he has
Where
not.
is the agreement?
Agreement, my lord, that is development agreement, my lord, kindly see that clause 12. That is clause 12, page 24.
Page 24.
Page 24, translated copy. Bottom part, my lord. The decision. If in future any dispute or difference of opinion arises with respect to this agreement and construction of the building, then this will be solved by a third party or one arbitrator, and both
third party
or the arbitrator or one arbitrator, and both the parties will bound to obey the said decision. If the agreement in clause, my lord. Agreement.
Give me an English translation.
Yes.
Otherwise, I may commit mistake.
What, my lord?
English translation is there.
Yes.
Bhubaneswar Development Authority is not appearing.
No, Bhubaneswar Development Authority is not opposite party, my lord. That is a builder who has signed the agreement, development agreement.
Who is the builder?
That builder, that opposite party, my lord. Namely, managing director that representative Jawahar Mishra was signatory to this agreement.
Despite service of notice, despite valid service of notice, the respondent has not entered appearance. This application is filed also.
My lord, may I submit suggestion name of senior advocate, my lord?
No. Because the other side is not here, no? What is the amount?
Amount is 2 lakhs or 2 to 4 lakhs. One land, one piece of land sold by the respondent, opposite party.
I am appointing an engineer.
Engineer? Yes.
So the Professor Dr. Subhas C. Gupta, can I have the address? Sorry, okay. Professor Dr. Subhas C. Gupta.
Item 8.
May I please? In this case, at clause 26, page 14, the arbitration clause is there. Notice has made sufficient. The lawyer already appeared. In the meanwhile, they have taken 5 to 6 days. And neither they have filed any counter affidavit. Your Lordship may appoint, the amount is 35 lakhs. And as per the demand notice on Annexure 4, your Lordship kindly grants at page
Subject to
36.
Service of notice. Opposite party number 1 had entered appearance. So today on call, there is no representation on behalf of the OP number 1. Earlier, when the matter was taken up on various dates, time was allowed to opposite party number 1 to file counter affidavit. Stop. Where is the arbitration agreement clause?
Clause at page 14, Annexure 1, page 14, my lord. Clause 26, my lord. I'm reading.
Page 14?
14.
Yes.
Ronnie page. Clause 26. All disputes and differences between the parties hereunto in any way relating to or connected with premises and or building.
All right.
My lord.
Clause 26 of the arbitration agreement of the agreement between the petitioner and opposite party number 1 is is the arbitration clause which reads thus. Full stop. It appears that opposite party number 1 is either avoiding or delaying the course of
And before filing this case, 30 days notice was served unnecessary, and demand notice was also served at unnecessary 4. The amount is 30 lakhs 16,260.
It has been submitted by Grand Counsel for the petitioner that all statutory compliances have been done for invoking the provision under section 11(6) of the Arbitration and Conciliation Act for appointment of an arbitrator. So, who should be?
Your Lordship may appoint, as per the panel list, I don't have any objection. This amount is 30 lakhs 16,000. Any senior advocate?
Datta. S.K. Satpathy, retired IAS.
Yes, Lord. I don't have any objection.
Is it there?
Obliged.
Item 9.
We are similar in the next class.
For the opposite party, my lord, kind of 1 week's time, my lord.
You.
UP opposite.
Sorry. Sorry. This application has been filed for appointment of an arbitrator. The arbitration agreement is there. So one arbitrator has to be appointed. That has been done. That's all.
In this case,
If you say
ready to pay. In this case, opposite party ready to pay, but he has not completed the work in proper time, my lord.
Who?
Petitioner.
That aspect cannot be gone into in the present
dispute.
proceeding. So if you suggest one name,
Yes.
then we can do that. Suggest name.
My lord, your lordship fix any.
So if you,
I don't know.
you can suggest a name.
Any decisions, retired decisions, your Lordship may suggest. We have
Retired-
44 lakhs.
Retired decisions. Suggest one name, Mr. Counsel.
Saroj Das, Advocate Saroj Das, if I.
Advocate?
Saroj Das.
Saroj Das. Senior advocate.
He also knows.
Senior advocate. Is he a senior advocate?
He is not designated, but senior.
But his name is not there.
In the panel, his name is there.
Serial number 16. Murlidhar Pradhan. A senior advocate. Advocate.
Your Lordship, Santanu Soding. Your Lordship, Santanu Soding, Mr. Santanu Soding, your Lordship may suggest. He is also senior advocate.
So, Mrinalini Padi.
Yes, Lord. I do. Obliged.
Item 10.
May I please, your lordship?
In this case, I am appearing for the opposite party, my lord.
I have filed a counter and copy has been served.
I have already filed the, may I please your lordship? I have already filed the rejoinder affidavit.
He has filed a rejoinder today online.
Today
Copy has been served on my, copy has been served. So, also call it some other day, I'll take instruction on the rejoinder.
What objection is there? What is your objection?
For appointment of arbitrator, madam. But in fact, he has been paid everything, man. Nothing, no.
Might have been paid.
Yes.
He might have been paid, but he has raised a dispute. This court is not required to go into whether he is entitled to or not entitled. He is just seeking appointment of an arbitrator.
But in fact, now there is the recent judgment, madam. That must be a valid and live claim, madam. Here, madam, here is I have also included document page 96 of my counter. He wants that the amount towards he has himself said hereby certify that is page 96 annexure D by 2. That is petitioner reliable high-tech infrastructure private limited. Hereby certify that having completed the works entrusted to us on contract in accordance with the condition, the agreement contract on having received all payments due in respect of the contract in full and final settlement, except the security deposit, we hereby claim the refund of rupees 72 lakhs 29,754, being 100% of the total security deposit lost by us, and hereby tender receipt thereof. Then they have given a receipt that he has received that also security deposit of 72 lakhs. So no further dispute exists between the parties.
May I please your lordship? May I please your lordship?
Just a minute. Where is the Supreme Court's decision? Is it before 2015 amendment or?
No, this is the 2024 5 SCC 313.
What is the decision?
In fact, I have just, I have not.
You have not gone through.
I have just.
And we are relying on.
No, I have not.
All right, next week. Next week, as the question on behalf of
Can it be
the
called a week after, madam?
opposite party, list this matter on next Wednesday.
Well, next Wednesday, I'm not there. I'm out of state.
All right. Stay week. All right, after 2 weeks, Mr.
Yes, ma'am.
Yep. Oblige, Lord.
Item 11.
Pursue item 11 on behalf of Mr. Yuvraj Parekh. His wife was died on last 7 days. Let us pray for 2 weeks time to file rejoinder.
2 weeks?
Time to file rejoinder.
Lord, I am on behalf of Mr. B.P. Tripathi for the opposite party. We have filed the counter.
Why are you objecting?
Lord, our submission is that in the counter that it is a time-barred claim, Your Lordship, and that is the ground.
All right. As requested on behalf of the petitioner, list this matter on 2 weeks.
Item 12.
Arbitration clause is at page 18. Item 12, we both have agreed for the name of Dr. Justice A.K. Mishra.
Item 13. Item number 13.
Yes.
May I please, my lord?
Who is for the other side?
And for the
Yes.
operator number 1. And for the operator number 1.
Any objection?
My lord, they have not complied the subsection 3 of the section 11. They have not given any.
Item 13, my lord. I am on BC, my lords. I am for the OP number 2. I pray kindly taken up next week, my lords.
No, why? He says that there has been 11.3 has not been complied with.
Yes, my lord. My lord, unfinished submitting that I have not complied means I have not suggesting a name, but I have given a registered letter. Thereafter, my advocate has given letter and he has given reply. My proposal, my lordship, may appoint anybody as
How can, unless there is, statutory requirements have been fulfilled,
Our mind learned friend may suggest a name, I don't have any objection.
there is no question of suggestion of name. We are I am exercising power under 11.6.
My lord.
Now you will have to demonstrate that all the stages had passed, like you had given him notice. No notice was given.
Your lordship kindly have a glance at the page 29.
Yes.
I have given notice. And last paragraph I am suggesting. Page 33, my lord, relevant person.
Yes.
My lord's notice per 9. Hence, you are hereby requested to extend your consent within 7 days from the date of receipt of the notice for appointment of an arbitrator to arbitrate and resolve the dispute. Moreover,
So when was this letter sent?
my lord,
When was this letter sent?
this letter was 7/2/24.
And when was it received?
He has received it. My lord, it is on 9/2/24, my lord.
When did you send? 7/2.
My lord.
And it was received on 9/2.
My lord, 9th February.
Anything?
My lord, they have not they have not given any suggestion in their notice, my lord. Only sent the notice, but they have not suggested any arbitrator.
Suggestion that is not required. This appointment of sole arbitrator or what?
Yes, my lord.
Where is the agreement?
My lord, agreement is, your lordship kindly peruse the page 15, paragraph 15, my lord.
Paragraph
15, my lord.
page 15.
My lord.
Arbitration conciliation. Yes, come to clause 15. 15 of the agreement.
My lord.
Is right.
Each person says select arbitrators. My lord, first I have given offer and he didn't accept it. Therefore,
There is no question of his accepting. You could have said that there is a dispute. Now it is to be resolved through this process. When you are suggesting, you have selected an arbitrator. Then only he could have selected.
my lord says power and I am suggesting a name if my learned from the.
It is a premature match.
Yes, premature.
Which provision will apply in this case? It's a peculiar case where under the agreement, 2 arbitrators were required to be appointed. There cannot be any arbitration tribunal having 2 arbitrators. Suppose there is a provision for umpire, but
In the reply to the legal
please
notice,
examine the legal aspect.
my lord.
Please examine section 11. Section 11 speaks of 2 things. One,
My
sole
lord.
arbitrator, and the other 3 arbitrators.
My lord.
There is no provision for 2 arbitrators in section 11.
My lord, here is the case, my lord. My learned friend is totally disjoining that there is no arbitration clause and nothing. Your lordship can have a glance at page 35.
Forget, Mr. Counsel, you have to make submission, I have to write an order.
My lord.
So I'll have to see
My lord.
under which provision you are saying you invoked section 11. So under section 11, your agreement arbitration clause says that each of the parties shall select 1 arbitrator.
My
So
lord.
2 arbitrators. So 2 arbitrators will decide the dispute. And then if there is any difference of opinion, then that will go to the umpire.
Umpire, my lord.
That is not there. And if that is there, I might have missed. Please examine the legal aspect.
Yes, my lord. And
The
one more.
specific claim is not there, madam, to decide. Specific claim also not there.
Please come with.
Until and unless arbitration.
Please examine this.
My lord, my lord.
Item 14.
In item 14, your lordship can be permitted to appear in virtual mode. In fact, in this case, the notice has been made sufficient since 5/7/2024, but no one has appeared for the respondent. May I pray, my lord, may kindly, if my lord may kindly permit me, may I suggest someone's name so that my lord may consider to appoint him as an arbitrator.
Where is the dispute?
The dispute is
clause.
my
Where is
lord,
the
clause is 62. Clause 62, my lord. Page 39, my lords. Your lordship may kindly see 62A.
Page 39.
Yes, lordship. The claim is all about 40 lakhs some odd, and it may, because of the interest and other things, it may go up to 1 crore, your lordship. Because the interest part is there, your lordship, it may, and your lordship, in the agreement, the address, whatever the agreement is there, my lord may kindly see page 20. The same address I have furnished in the arbitration petition. Notice been made sufficient. They are not appearing.
Since when they are not appearing?
5/7/2024, my lord. Notice been made sufficient. There is a official report of this Honorable High Court.
Despite valid service of notice, the opposite party has not entered appearance. So, this application has been filed so and so. Let me see the arbitration agreement again.
My lord.
Where
My
is
lord, page 20, my lord. Arbitration agreement. Page 20, your lordship.
statements made in the present application for appointment of application have thus remained uncontroverted. The point of the appointment of arbitrator. Stop. This dispute relates to what?
Your Lordship, it's a dealership agreement. The dues are pending and they are not paying it. And it's a Indian Oil Corporation, it's a public sector undertaking of the Government of India. They are not paying the dues because they have utilized the lubricants and oils and other things. And Your Lordship, what I pray, my Lord, if my Lord allows me to suggest the name of an arbitrator, I may. Or
No,
else,
you cannot. You will not.
my Lord.
Since other side is not appearing, therefore.
May I take Dasti summon, my Lord, if my Lord allows?
Dasti summon, yes. No one appears. Dasti summon. Yes.
The whole issue is, my Lord, because the address is correct and they are not appearing.
All right.
My Lord.
Item 15.
Deeply obliged, Lordship.
Item 15, I am for the opposite party, Lordship. I just served the counter affidavit today.
So are you opposing?
Yes, Your Lordship.
Ground.
On ground that they want to initiate a second arbitration proceeding from the same agreement, Your Lordship. After a lapse of time of 15 years, Your Lordship. They have already invoked the arbitration agreement in 2009. Right now, again, they are trying to invoke the.
And what happened?
Your Lordship, the arbitrate tribunal was formed. In between, not to the finality of the arbitral award, but to the acceptance of our counterclaim, they filed a writ petition, which was not maintainable at that point of time in 2012. Suddenly, the matter comes in 2023, and by the time two of the arbitrators expired in between, they did not proceed with the writ petition for the last 12 years. And suddenly in this writ petition, when I was supposed to file the counter affidavit, they suddenly went for a withdrawal of that writ petition and took a liberty to file a fresh arbitration petition under section 11(6).
What is wrong in it?
Your Lordship, I have some judgments to be given before Your Lordship, Your Lordship. I have not today come with the judgments that one party could not go for a two arbitration proceeding from a single agreement.
No, that arbitration proceeding remained inconclusive.
Yes, Your
That
Lordship,
too
but there
because
is
of the death of the arbitrators. No.
yes, Your Lordship.
So how will the dispute
They
be
suddenly
resolved?
abandoned the arbitration proceeding and went for a writ petition, Your Lordship. So there is a limitation which has been prescribed in Arbitration Act, Your Lordship, which has to be followed. And after an amendment of 2015, if Your Lordship may see 29A, there is a time limit for an arbitration proceeding which has to be settled in 12 months or can be extended for an further 6 months, so total 18 months. So they have crossed that limit, Your Lordship. If they wanted, they could have pursued the writ petition, they could have disposed it of in time and could have proceeded with the arbitration proceeding. But they didn't. They waited for last 12 years, Your Lordship. And suddenly they come with another 11(6) petition, Your Lordship, before this honorable
It
court.
is stated by you. When did you serve a copy of the counter?
Today itself in the court.
A copy of the opposite party has entered appearance by way of a kalatnama. A counter affidavit, a copy of counter affidavit. The opposite party. Only a sole opposite party.
Yes, Your Lordship.
The sole opposite party is opposing the present application for appointment of arbitrator, mainly on the ground that the arbitration clause was earlier invoked by the petitioner way back in
2009.
2009. So, it is contended that this application for appointment of
Arbitrator.
sole
No, arbitrators, there should be three.
For appointment of arbitrators is not maintainable. So stop. List this matter on. A copy of the counter affidavit has been served on learned counsel for the petitioner today itself. List this matter on when? 2 weeks?
Your lordship, 4 weeks may be granted for to file the rejoinder. We will file our reply in the counter.
Will you do in 4 weeks? All right, 4 weeks.
Then after vacation.
I'm not 16.
Oblige.
16, your lordship, I need some time to file the counter. 16, I need some time to file counter.
Who has filed the application? You have filed application?
No, I had filed the application, my lord, for appointment of arbitrator, my lord. My learned senior seeking time for
3 weeks time is allowed for the learned counsel appearing on behalf of the opposite party to seek instruction and to seek instructions and file counter affidavit. In this case, 3 weeks.
Item number 17.
My lords, here, there's an arbitration clause at page 59. I am a supplier of medical equipment to the Orissa Medical Corporation, my lords. The lordship kindly sees.
No, who is appearing for the other side?
State, my lord, medical.
Well, on behalf of Mr. VP Tripathi, I am appearing for the Orissa State Medical Corporation. I pray 1 week time, my lord, to file the counter. I pray 1 week time. We've received the instructions, only the counter is to be
Yes, let him file affidavit.
Last chance.
As a last chance, my lord, 1 week time.
Earlier time was granted.
Earlier time was.
As a last chance, your lordship, I am praying for time on behalf of Mr.
By way of last indulgence. 1 week further time is being sought on behalf of the opposite party to seek instruction and file counter affidavit. This case on 2 weeks.
Item 18.
Publish.
I am appearing for the opposite party. I'll file the counter affidavit in course of the day. I've received the copy in court now. I'll file it in course of the day.
You are for the opposite party. You have filed counter affidavit.
Today I will file it.
You will file. You are opposing.
Yes.
As counsel representing the opposite party submits that he is going to file a counter affidavit opposing the application for appointment of an arbitrator. So stop. As requested, list this matter on 1 week.
Item 19.
From 19, we are appearing for the opposite party. So it's time to take, yet to receive the instruction regarding the matter.
Yes. How much time?
2 weeks.
2 weeks. Yes.
Item 20.
Item 20, my lord,
Item
20, your lordship, permitted to VC, your lordships. Item 20, there is a negotiation, compromise going between the parties. But I need only 4 weeks time to.
I'm for the opposite party. We have paid more than the 50% amount of the amount. Negotiations are going on, Milods. Post it post puja vacation so that it can be settled, Milods.
Counsel appearing on behalf of the parties have submitted that the parties are in the process of negotiation and there is very likelihood that they shall resolve the dispute amicably. So stop as requested, does this matter? 4 weeks, yes.
Item 21.
Lord, 21, I have instruction, I am appearing for the opposite party. Lordship may kindly refer to page 22 of the agreement.
My lordship, on behalf of advocate Devidatta Panigrahi, is suffering from fever as per my instruction. 1 week.
time may be granted.
1 week.
Well, I will file our affidavit, my lords.
Plus this matter, you are for the petitioner.
My lords.
As requested on behalf of the petitioner, list this matter on 2 weeks. Stop time in the meanwhile may be utilized by land counsel representing the opposite party to file a counter affidavit if so required.
Item number 22.
Your lordship, there is a clause is sole arbitrator. Your lordship last time direct to take instruction to my learned friend.
Your lordship may kindly grant me 1 more week time. Instructions have not come.
As jointly requested, list this matter on 1 week. Yes.
Item 23.
My lordship.
23, your lordship, also I am making the same prayer. Lordship may take it up next week. 24.
24 minute file में वकालत ना next week. I have served the copy, my lord. You have served the copy, my lord. File में वकालत ना. It is stated by Mr. So that he has instructions to appear on behalf of the opposite party.
Last date they appeared.
Last date only have to file में वकालत ना, my lord. Therefore, we have not filed your वकालत, my lord. And he has received wakalatnama, which he shall be filing by within 2 days. Wakalatnama you will file, when will you file your wakalatnama? Well, within 2 days, I'll file. Man. Let me take on next week, not file with. By Monday. So place this matter on 2 weeks. Objection be filed in the meanwhile. Comma is so required.
Obliged.
Matters in specialist. Orders item number 1.
My lord, in this case, my lord, the legislator said to the petitioner, my lord, sole of petitioner with accused, my lord, is returned with a endorsement that this is my lord.
And counsel for the petitioner has stated that he had written a letter to petitioner about dependency of the case. So he has learned that the petitioner is no more. So a memo to this effect has been filed. So this application stands, this application thus abates and stands disposed of accordingly. Yes.
Item number 2.
This is your lordship. I am there online. Lords, I have prayed for restoration, recall of your lordship's order, dismissing the criminal revision for default. Annexure 1 is the order.
This is the application for recall. The present application has been filed for restoration of criminal legislation number 287 of 2000, which was dismissed for default by an order dated 23/2024. So the bail bonds furnished by the petitioner were ordered to be cancelled. So considering me, what is your stand?
Lords, my stand is that there was no communication between me and the council, my lords, and my council stated to me that he had missed the list. When I came to learn about the dismissal of the revision because the order was communicated to the lower court, I contacted counsel. He said that he had missed the list.
Yeah.
missed the list.
Missed the list. Sorry.
Your Lordship may call it any day, my lords. After 2 weeks, I'll get ready. And
The order to be cancelled. Considering the statement made in the present restoration application, same is allowed. Criminal revision so and so stands restored to its original file. It is further directed that the petitioner shall remain on bail based on the bail bonds furnished pursuant to this court's interim order dated 1/6/2000. Yes.
obliged. And urgent call.
Urgent you will.
Item number 3.
At this matter, I would pray for 3 weeks time to take instruction because first time long gap, I don't know what is the status or I have no contact. I pray for 3 weeks time to take instruction any date after 3 weeks.
One week. As requested on behalf of the petitioner, is this matter on? 1 week. Yes.
Item number 4.
Dismissed.
Item number 5.
My lords.
May I?
Which item?
Item number 5.
Item 5.
Four no. We at liberty to make an application for restoration.
Item number 5.
Yes.
My lord, item 5 I was appointed as amicus curiae in this present case, and my humble submission, my lord, that.
And who are you, Mr.?
I am the Ashok Kumar Mahapatra associate.
You are for whom?
My lord.
You are appearing for whom?
The petitioner's name, Mr. Mahapatra's name appears for the petitioner, and he says that he is associate.
My lord, so this the Ashok Kumar Mahapatra name the item so that I.
Yes.
My lord, in this present case, since nobody was appearing, so I was appointed as amicus curiae. And
Whether
the
he is alive
case
or
of the
not.
petitioner, case of the petitioner is that.
Mr. Counsel, whether he is alive or not.
Petitioner is alive or not.
Sir, also there is no instruction, my lord, and the sentence was for 3 months, and it's around 24 hours. If petitioner will be
Yes.
alive, at least that will be 70 years. He will be, must be 70 years. So,
My lord, the Councillor Ashok Kumar Mahapatra has expired. My lord, we need take instruction for the client.
This revision application has remained pending before this court for 3 years. For 23 years. So stop. The what is the date of the trial court?
my lord, the order was passed on 3rd August 2001. 3rd August 2001.
The petitioner stood convicted of the offence.
Offence under, my lord, under section 7 of Essential Commodities Act, EC Act.
The section 7 of the Financial Commodities Act by court, which court?
My lord, vigilance, it is a special judge vigilance, Kotak, my lord.
Trial court.
In the court of special judge vigilance, special vigilance, trial court. This is the trial court. Special judge, special vigilance judge, Kotak. Against what is the appeal?
Oh, this is against your order of conviction.
Yes,
not against the
order of conviction of 3 months, my lord, and the commodities are
trial court. Trial court. First court.
Sita against a trial court record nahi aate.
Revision केम झाला? आपण जो order टा पहिले appeal रे ना original court.
सेटा होची vigilance GR case number.
Vigilance
GR का हाँ.
Vigilance GR केम जाऊँ? 7 EC Act vigilance केम जाऊँ?
by a judgment dated 3/8/2021 passed in Vigilance GR number 115 of 1997. What's wrong? Petitioner stands. Petitioner has been sentenced to imprisonment for a term of 3 years. Post officer judgment of conviction and the order of sentence are under challenge in the present criminal division application filed under section 401 of section 397. There is section 401 of the CRPC. Yes. Or reason is maintainable.
Yes, sir. I don't know because vigilance case, it's a vigilance proceeding. They are special counsel, but that is why I think.
No, revision. See, any order against which there is no appeal.
If there is no appeal, revision is maintainable.
Revision is maintainable.
Yes, that is true.
No appeal will lie against this order.
Yes.
Yes, my lord. Vigilance case number GR case number 115 of 1997. Order passed on 3rd August 2001. Conviction 3 months.
But nothing can be done unless it is known that whether he is alive or not.
Yes, my lord. Another thing is, my lord, in this case, the high-speed diesel which are seized, that has also been sold in the presence of the collector. So there is nothing rarely leaves anything for adjudication, my lord. And because of his age, my humble prayer is for acquittal of the accused person. And there is no instruction whether he is living or alive.
Report from the Superintendent of Police, which place?
My lord, Prahalad Panigrahi, village Sompur, Kishan Nagar, district Cuttack.
He was 72 when he had filed the.
Yes.
My lord, he was 72 or he must be 96 if he is alive.
Take a report from the Superintendent of Police. Cuttack as to whether the petitioner is alive or not. Two weeks.
No.
Item number 6.
In fact, we shall supply you list of cases.
Yes.
All right. Those 2001.
Right.
So in such cases where the petitioners are alive, we can take up those
matters
are
are automatically others will abate. That report is not.
So that will help clearing old matters.
Right.
Item 6.
Item 6, my lord. Again, I am amicus curiae in this case, and the petitioner while bringing this revision petition was 45 years, 46 years. It was 70 years by this, and offenses under section 397 and 48. Sorry.
324,
324 and 448. And
what is the
was
sentence?
convicted for 3 months.
Huh?
Was convicted for 3 months, my lord.
Conviction is not for 3 months. Conviction is for an offense.
Yes.
for 3 months.
Yes, sentence for
Sentence is for
3 months.
All right. For conviction, sentence is for 3 months only.
Like
397.
No, 324 and 448 minutes. House trespass.
House trespass.
Yes. Oh, this is also same. Diesel, high speed, same thing?
No, it's different.
Sorry.
It's different.
It's a case of, my lord, cooperative society where
Item number?
item of 6.
6. Conviction is under 324 and only 324.
Yes, my lord.
324.
324, 448.
Hmm? Okay, 24 and 448.
Yeah.
What is the minimum sentence?
Minimum sentence, it's up to 3 months to 7 months.
All right. I'll see next Wednesday. Next Wednesday. So you just addressed me on the point of section 324. So whether that finding is correct or not.
Yes, ma'am.
And secondly, you can address on another point also. That
448, my lord, is not exactly house trespass because it is a waiver society. And the.
so therefore you forget 448.
Yes.
You just address on 324.
Yes.
And
Yes.
address on 324 also.
324, my lord, in this regard, my humble submission is this. Grievous hurt by no weapon, but whereas he has picked up a table lamp and just had assaulted because of there is a misunderstanding between the petitioner and the complainant, informant. So he went to the society, over society, to purchase some bundle of threads. It's a very minor issue, my lord. So he purchased 10 bundles of threads, and when he came back to his house, he found that the counting is wrong and it was 9 bundles. He returned back. It was 9 bundles instead of 10 bundles. So he returned to that society and again have his objection that no, there are 9 bundles and you have to give me another bundle. So therefore, there is a altercation between this the member of the over society and the appellant. This is the issue only. And say being aggrieved, she got a table lamp tha. So table lamp, he just assaulted him on that table lamp and he just got minor injuries. And this is the offense only.
Sir, one more prayer. She gave 2 numbers to my friend, those contempt numbers. One relates to school and mass education. I have sought for instruction, I can get that. The other one relates to transport authorities. They've got a different council that is not available in our office.
How's the other council?
I will intimate him, but so far as other is concerned, I will try to get it done in the meantime.
Yes.
My lord, next item, my lord, is item number 7.
Next item, yes.
It is a matter, my lord, it has been compromised before the appellate court. So far, section 324 is concerned, the learned appellate court has compounded. But so far 307 is concerned, he is dismissed my appeal. So, and we have filed affidavit here also. In the injured and the informant, they have filed affidavit. 93 was the occurrence.
That is not permissible.
90.
See what can be done. I'll see what can be done, but that cannot be.
But regarding sentence, your lordship.
Sentence, yes.
Yes. Just 7 years sentence as 93.
7 years.
Yeah.
And how many?
Only one accused.
Huh?
Only one accused.
No, but what is the period of his custody?
Undergone, my lord, 3 to 4 months. I have not seen, but from my record, I found that 3 to 4.
Just examine that.
Yes. My lord, not next Wednesday, Wednesday next.
All right.
1 week. Okay.